with us. So please, I would like to ask that when going into a licensing or a merchandising deal, what are or a relationship? So I'm a creative, I want to, or I'm a filmmaker, I want to license my film to a Netflix. What are the associated risks that could be involved? And what are the ways that we can actually mitigate this risk? Thank you.
Thank you very much. Okay, I get what you said with the example you've given with Netflix, which is for maybe the entertainment industry, but just to quickly mention that it's really helpful for us to always have at the back of our mind that the creative industry is much more than the movie industry, right?
Definitely.
So it includes music, it includes film, theater, fine arts, dance, fashion, advertising, print, radio, television, and so on. So, I mean, it's a multi-billion-dollar industry, and anything we're discussing or everything we say, would also be applicable in any of these other areas, whether it's entertainment, movie, or whatever or not. So in that regard, I know that it's a very, typically unfamiliar, technical, confusing for a lot of people, to enter. And so it is important and very critical that people understand what they are going into in the first place. It's very good that we're having these conversations on intellectual property, what's intellectual property, and all of that. The point for me is before you as a creative even decide to enter into any licensing, merchandising relationship with another party or any partnership and all of that, you need to understand what IP you have. Okay, so what's the IP that is at play in this circumstance? These relationships are largely contractual, right? And so it's about you, excuse me, I'm a bit under the weather.
Sorry.
Excuse me.
Sorry,
it's about one party entering into an agreement with another party. But before you do that, you need to understand your position, right? What's my IP? What are the economic rights here? Which IP do I have here? Is it the name? Is it the movie? Is it copyright? Is it, what exactly is it that I have? That's something that you need to clarify, because that would determine, first of all, your negotiating point, and how you go. There are a lot of opportunities, really, but how you go about it depends on what IP you have, and if you have clarity as to what that IP is. So first of all, make sure you know your IP, make sure you've secured it, because sometimes you might feel that you own the rights to a particular thing, whereas you don't, So I'll give you an example. Maybe you've entered into some agreements and all that, and the copyright belongs to other parties as well as you, or even to other parties that are not you, and then you go and negotiate an agreement with another party based on that copyright that doesn't even belong to you. Then you realize that you're going to run into trouble, so that's the first thing. The second thing is look at the money issues. A lot of times people downplay this because we're not experts, maybe in financial issues. You need to know what are the royalties, what are the payment terms, who gets what, how do you get it, and all that, where this money is going to be paid to, and things like that. These are things that you need to be very clear about, and then be sure that you're negotiating the right thing. Okay, don't go and negotiate an outright sale or assignment when what you want to do is to negotiate a license, right? Be sure that you're not telling them. You watch out for what, like perpetuity, or total handover, or some transfer in totality and things like that. Okay. In terms of sales, what comes to you? What royalties are you going to get? If there's any sales that's made, what will come to you? So there are a whole lot of issues that you would need to look out for. And that's why I would typically advise anyone that's getting into this kind of agreement or deals, make sure you have a lawyer, excuse me, advising you, a lawyer holding your hands and all that along the way. Because like I said, these terrains are very unfamiliar, technical, confusing, and complex. They are very interesting, but if you are not careful, oh, I'm so sorry.
Sorry.
If you're not careful, you would end up signing away rights that you didn't plan to do so. Excuse me. The story is told of them, and it's actually a true story, right? I don't know how many of you are very familiar with Dora the Explorer. It's an old old kid, I think early 2000s or so. There's this lady, Kathleen Hurley, who used to play the voice of Dora, right? And when she was contracted to do the thing, she was just told, okay, you'll be given some rights, this and that, and she signed an agreement, which she said, according to her, it took her just 22 minutes to sign, and that it was unconscionable and all of that. But then Dora the Explorer went on to become a very big hit. And I mean, I don't know that there's any little girl or whatever, even boys that don't know about Dora the Explorer. It's been translated into so many languages and all of that. And then she came to sue Nickelodeon, MTV Networks, and Viacoms and all of that, claiming that they've made millions of dollars and she was only paid very little for her voice that was used. But hey, that was the agreement she signed. I don't know how that was sorted, but I always use that as an example when I'm talking about these issues, right?
Thank you.
So you talked about the opportunities and risks, right? The risks, I would say, is that if you're not careful, you could sign away rights that you didn't intend to sign. If you're not careful, you could lose part of what could have made you fetch you a lot of money and all that. The agreement should be very carefully looked at and all that, so that you don't you don't get, shoot yourself in the foot and all that. The opportunities is that there are lots of opportunities for expansion, exploiting your IP, commercialization. If you enter into licensing agreements, partnerships, and all of that, you're able to reach further than you would have reached if it was just you handling your stuff by yourself. You're able to get a wider audience, particularly if the other partner is well known and has more contact and it's a bit more international and all that.
Thank you so much. We're almost running out of time. Thank you so much for the robust explanation. Thank you. So please, I would encourage us if we have any question, because we're about to round up this session. So please, if you have any question, please let's drop it in the comments so that we can ask our panelists, please. So we have less than 5 minutes to close this session. So I will quickly go back to the panelists. I will give each panelist like 30 seconds just to say their final words before we close this panel session. So I would start with Trust. Trust, please, are you there? A final word from you before we close. 30 seconds, please. Okay.
All right, thank you very much.
All right.
I'm still here.
Okay.
So for me, I would want this conversation to keep going. For that, I would want the awareness to be out there, because as an industry, it's really, really important, because this particular conversation is going to make or break lots of designers moving forward, right? We've seen the likes of Zara, Tiffany & Co., and how this licensing IP whole thing has given them strength out there in the West.
Thank you. That's it's 30 seconds already. So thank you so much. So we should keep the awareness going. Thank you. So Fola Shade, please, 30 seconds.
Okay, thank you, Omotayo. So I think finally what I'll just say is, if you're a fashion creative, be proactive and business differently. Like, do business like you are educated and you know what you are bringing to the table. Yes, what you're bringing to the table. So just don't be proactive. Yeah, basically, just tick all your boxes and dot your I's and your T's when you're doing business.
Thank you. Inky, your final words, please. You have 30 seconds.
Final words. I agree with all the speakers, and I think everyone should make sure that they keep themselves aware of the goings on in the creative industry. They educate themselves, and also they hire a good lawyer whenever they have a deal to negotiate.
Okay, Chinasa, your final words, please.
Yeah, just to reiterate that the creative industry is a very important industry. According to Joberman, it's positioned as Nigeria's second largest employer, and we should take it seriously, look at the opportunities, mind the risks, and ensure that we make the best of it. Thank
you. So please, while you were speaking, a question just came in, and I would like to direct it to you, Chinasa, since you are here. So the person asked, can a foreign company with an unregistered trademark here in Nigeria enforce their trademark against anyone with similar trademark already registered here in Nigeria?
Well, the general rule is that Nigeria is a first to file country, right? Like first person to file a trademark, takes preeminence. However, there are exceptions, right? So if that company is able to prove certain things, for instance, bad faith, and so on and so forth, like, yeah, he might be able to, enforce his rights.
Okay, thank you. So I hope that answers the person's question. So on a final note, I want to say thank you to all the panelists for the wonderful presentations and answers. And I would like to say that on a final note, please, there are basic things that you should take away from this session. And the first thing is, as a creative, you need to be aware of your intellectual properties, know your trademark, know your copyrights, know your patents. What can I trademark? What can I copyright? And the best way to actually do that is to always work with a lawyer that would actually hold your hand and put you through all this process. And when you have licensing and merchandising opportunities, also involve a lawyer. Like Madam Chinasa rightly said, the creative industry is the second largest employer of labor in Nigeria after agriculture. So that means that there is a huge opportunity in that industry. So just like your real estate, identify your intellectual property, take steps to protect them, and always take the opportunity to monetize them, because it's useless if you don't monetize them. You can't create products just to sit on them at home. Monetize your intellectual property and you will get more value from it. Thank you so much for the opportunity. Thank you. Over to you, Damilola.
Thank you so much, Omotayo. That was truly a brilliant discussion. Thank you for helping us pick the brains of all our panelists and ensuring that they have delivered value to us today. I'm a creative, so this particular session was very enlightening for me, and I'm definitely taking myself more seriously, and I'm glad that I've listened to every single one. I want to say thank you as well to all our panelists. Thank you for sharing from your wealth of wisdom and knowledge with us. Thank you for being a part of IP Annual Discourse 2023. If you enjoyed that panel session, I just want you to put one word to describe the panel session in the comment section. Put one word that you can describe the panel session that we just concluded. What was it for you? Was it insightful? Was it enlightening? Was it mind-blowing? Just put that one word in the comment section so that our panelists can see your feedback and know that you really appreciate their coming on board to share with us today. Thank you very much. Rosemond says enlightening, Obina Egu, informative, Cephas enlightening, Ntande insightful, beautiful, beautiful, beautiful. I'm glad that we're all paying keen attention. I earlier on said today that it's a day of full conversations, rich conversations as well. We're moving on to the next panel session. This panel session is looking at trade and investment policies for business sustainability. The objective of the panel is to emphasize the importance of a good IP system in Nigeria, identify tactics for effective implementation of the national IP policy, as well as encourage both private and government institutions to collaborate towards implementing the national IP policy. Now, all of this is in a bid to enhance innovation and, of course, business sustainability. To moderate this panel session, we have Shukurat Amosta. Can we please put our hands together for her and welcome her as she takes the stage? Hello, welcome.
Can you hear me?
Yes, loud and clear.
Okay, so let me just confirm that you can hear me, because my
We
net.
can hear you, but from my end, your video appears to be glitching. Okay, it's fine. It's fine now.
It's glitching on my end too. I don't know what's going on.
Oh.
But no problem. So let's just dive in.
Let's go on. All right then.
Yeah. So I welcome everyone to this panel session. All protocols duly observed, and kudos to the previous panel session. I mean, they did amazingly well. and they spoke about IP in the creative industry. So let's take it further to IP in the trade industry now. So on this panel session, we'll be talking about trade and investment policy for business sustainability. So we've talked about creative. So now how can you sustain your business using intellectual property? So on this panel session, I have 4 panelists. And first off, I'll be introducing the first panelist. Okay, I'm sorry, my video is not coming up again. Is it okay? Can I just continue? Okay.
You can go ahead. You can go ahead, please. I'm sure it will come back on at some point. But just let's go ahead all the same.
All right, no problem. So on this panel session, my first panelist is a managing partner of Farmer Advisory, a boutique law and consulting firm in Nigeria. He is an international speaker, instructor who conveyed, hosted, and moderated several stakeholders and engagement in the life of policymakers as well. So on this panel session, let's give it up to Chineye Iwanaka. She will be our first panelist for this session. Do we have Chineye in the house?
Yes, I'm here.
Okay, I can't see the claps rolling in. Come on, guys, we have a policy maker here, and we are dulling ourselves. So give it up for Chiamaka Chineye. On the our second panelist for this session is a global vice president and African representative of the Global Members Advisory Board at the International Republican Institute Generational Democracy, and was a 2020 most influential young leader in 2022. So this panelists solve complex businesses and institutional challenges through the lens of legal, policy, sustainability analysis. It provides legal and policy support and advisory to tech companies and policy. So the panel session, the panelist in this session is Mr. Timi Olagunju. So let's give it up for Mr. Timi Olagunju, also a panelist as also a policy maker as well. So we have 2 policy makers now. We go on to the third panelist, which is person of Dr. Ifeoma Oluwasemilore. She is an intellectual property and related rights specialist with special focus on policy framework to enhance and develop youth and gender entrepreneurship in Nigeria. She's a member of the Nigerian Bar Association, Nigeria Association of Law Teachers Members, Nigerian Library Association. She is also a chartered librarian member, American Association for the Advancement of Science Pacific Division. So let's give it up for Dr. Ifeoma Oluwasemilore. She's also a senior lecturer at the Faculty of Law, University of Lagos. Oh wow, this session will be very insightful with the lineup of panelists. And our last panelist here is a person of Mr. Oluwatife Sonya, a legal practitioner, arbitrator, IP valuer, and auditor, and technology law expert. Is a managing partner of Party Solicitors, a firm service law firm where it regularly advises fintech startup on data privacy, data rights, trademark registration, and intellectual property management in general. He is also the chairman of the Young Lawyers Forum Nigerian Bar Association. Like, we have more lawyers and policymakers in the house. So this session will be talking about basically trade and investment policy for business sustainability. So we're looking at IP and policy as well. So before we start these policies discussion, I'd like to take us back to when COVID-19 struck. You know, business owners, everybody were at home and nothing was really going on. But we are amazed that during that period, IP came up. We were looking about intellectual property because most of us were online. So from that activities online, we noticed some IP infringements, just like some of the speakers said, the fashion industry, people stealing your designs online. But how can we cope all of these things? So that was why we got to know about intellectual property. Like, most people got to know about intellectual property. I'm like, okay, fine. So now we now know about intellectual property. What can we do? How can we use IP to sustain our business? And that's what we'll be talking about during this panelist session. So now my first question to Mr. Boluwatife Sonya John. Considering what I earlier said, how can you highlight the prominent importance of a good IP system for the growth of economic development, drawing insight from international jurisdiction? Yes, you're mute. Can you hear me?
Yes, sorry. Good morning. Can you hear me now?
Yes, I can.
All right, thank you, Shukurat. Before proceeding to answer your question, I must first appreciate the IP Business Capital for inviting me to this panel. And secondly, this is just on the sideline. I'm also glad that I'm on the same panel with Shukurat and Dr. Oluwashemilowe. Dr. Oluwashemilowe was my lecturer at the Harvard Law School Copyright X in 2018. So I'm glad to be here with her. So moving straight to answer your question, Shukurat, I would first start with saying I should explain what a good IP system should consist of in a country such as Nigeria or any other country. So, and I think the first is that there must be laws put in place to protect intellectual property assets. So talking about laws now, I'm talking about the Trademarks Act, the Patent Act, Industrial Design, Copyright Act, and the likes, Geographical Indication Act, Traditional Indication Act, and the likes. Going forward to the executive arm of government, which is responsible for the enforcement of these IP rights, must be proactive. They must not just be okay, good. Now, the first impact a good IP system would have is the employment system. You would observe that if there's a good IP system in a country, we would have a good number of employment. There won't be complaints of there's unemployment and all of that. So I'm going to draw an example from two countries, and the first is Morocco. Morocco has Again oil. Again oil is made from the Again tree in Morocco, and it has done a whole lot for Morocco. The Again oil alone, pardon, just a minute. The Again oil, yes, I'll just get what it's used for. The Again oil can be used to cook and can be used for the air. The ladies' hair, Shukurat may know what Again oil is. So the Again oil I'm talking about, in a year, we have over 52,000 persons who are employed in that industry alone of Again oil, just in Morocco. In the year whenever they export this Again oil again, they get per liter of the Again oil is about $400. So, and a liter is supposed to be made within 16 hours. So the implication is that within a week, I don't know how one wants to work, you could make as much as 10, 15 liters. So by the time you multiply 400 USD, which is per liter, multiplied by that, you won't be talking about unemployment. That is one. Two is ranked the ninth city that is mostly visited by tourists in Africa. So aside from them getting the financial income of selling their Again oil, they also have the opportunity of persons coming into their country to see the Again community. That's one. Two, the second example that I would love to give is the Darjeeling tea, which is from India. The Darjeeling tea is well known and is well exported. And they use, sorry, I didn't mention, they use the geographical indication, which is a type of intellectual property to protect this system. So the Darjeeling tea also is a tea that is being exported by Indians and also within. Talking about employment, it has brought in a whole lot of employment for India. And secondly, it has also brought in tourists to India. Talking about another effect of a good IP system. I hope I'm not taking too much time, Shukurat.
Okay, we can just try to round up. Fine.
Okay, yes. Then secondly, as the first speaker, I think Mr. Brenda had said, a good IP system would also bring in investments and trade. You would see if you have a good IP system, foreign companies will want to come into your country to say, oh, yes, I want to establish my company doing this in your country. But then if you don't have a good IP system, they will be scared. A good pharmaceutical company will not want to come into your country if they know that you cannot protect their drugs by patents. Also, it encourages the creatives to create more work. And by that, the government will get a whole lot of tax from that. So I'll stop here.
All right, thank you so much. So we've heard from Mr. Boluwatife the importance of intellectual property in an economy. And he has said so far, he said IP can help us with employment, like it's going to erase the issue of unemployment and give us more employment so other youth and everybody can have that particular work to do in that economy or in that society. Also, he talked about visitation, just like the geographical indication as well. And Mr. Brenda mentioned something during his presentation about how we don't actually look into geographical indication in Nigeria. And I think that's one thing we need to look into as well. We have different materials that can pass for geographical indication, like we say our Ijebu Gari, our Unsoka Pepe, and the likes of that, our Dodo Ikire, something like that. So those can pass for geographical indication. So if we key into IP the way we are supposed to, I believe it's going to create a very good business sustainability for business owners. Also, thank you for that. And going forward, we are going to address the next question, which I'm going to direct to Dr. Oluwashemilore. So now, talking about economic development, the World IP Day will be hosting this IP Celebration Day on the 26th of April, and the theme is celebrating creativity and innovation. So my question is this, Dr. Shemilore, can you please shed light on how IP can encourage innovation within the entrepreneurial ecosystem? How IP can encourage innovation within the entrepreneurial ecosystem? I don't know if Dr. Shemilore is here yet. Please, can we confirm if she's here?
Perhaps you can move on to Ms. Uwanaka. Okay. I think she has a bit of a technical challenge at the moment.
Okay. I actually wanted us to take the IP aspect before we move to policy, but since she's not around yet, then I'll move the question of policy to her. So from the previous discussion, the panelists.
No, hello.
Hello, can you hear me?
I lost you there.
Oh,
yeah, I was talking and nobody heard me.
I
was talking and nobody heard me.
Probably you were muted. Do you want me to come again? Should I take the question again?
Please do.
Okay, so I was saying that moving on from Mr. Boluwatife, we've talked about economic development. And I said that IP is set to celebrate the World IP Day on the 26th of April. And the theme for this IP Day is celebrating creativity and innovation. So what can you actually shed more light on how IP can encourage innovation within the entrepreneur system?
Yeah, thank you very much, Shukurat. I was actually talking, but nobody heard me. But can you hear me now?
Yes, we can.
Okay, all right, thank you. I might put off my video so that my network will be stronger, so that I don't, you don't lose me anymore.
Okay.
So briefly, I'll put up my video now and until my network gets stronger, okay? Thank you. Okay, so we're looking at how intellectual property can encourage more innovation within the entrepreneurial ecosystem.
Yeah.
That's the question, right?
Yes, please.
Okay, so I have listened to other speakers and everyone has highlighted and reiterated the importance of intellectual property, for in the fashion industry, in every aspect of the economy. So now let's look at how they can actually also encourage innovation in the entrepreneurial ecosystem. Intellectual property serves as the foundation of innovation in our economy. Government-granted rights incentivize discovery and creativity by providing creators with an opportunity to profit from the value of their innovative work. That in exchange, the creative work will be made public so that others may build on and benefit from the work of the original creator. Now, laws protecting intellectual property also reduce the transaction costs between inventors and industry by providing information about the quality of the invention without jeopardizing the ownership of the idea. For the entrepreneur, intellectual property in form of patents, trademarks, and copyrights can be especially valuable. Patents, for example, have been shown to have increased firm productivity and more immediately. A firm's market, it increases firm productivity and market value. Patent applications held by young firms, that's of course the young entrepreneurs, the small and medium entrepreneurship businesses, also correlates with higher valuations by investors, provided those applications are not software-based. So in essence, what I'm trying to say is that for entrepreneurs and the small and medium-sized entrepreneurs, especially when they apply intellectual property to their businesses, it also attracts investors to their businesses, because an investor who knows that you have a patent or you have a trademark in your entrepreneurship will be encouraged to want to do business with you and spend money on your business. Now, intellectual property protection benefits the economy. Sectors that rely on intellectual property represent a significant part of developed and developing economies in terms of GDP. So what I'm saying is that it's very important for, other speakers have talked about lack of awareness of intellectual property, lack of government policies to, yes, we have laws protecting intellectual property, but what is the enforcement? So government should also know that when they encourage intellectual property, it will also, it will grow the Nigerian's GDP, the gross domestic product. Now, IPR represents a significant part of a developed and developing economies in terms of GDP. Like I said, it encourages employment, tax revenues, and strategic importance. I was listening when they were talking about the protection in the fashion industry. And we know that Nigerians are very creative and we're quite talented, especially in the entertainment industry. So IPR, looking at the importance and how it can encourage entrepreneurship, also promotes foreign direct investments and technology transfers in developed and developing countries. So it is very important for our governments to be involved in intellectual property. And I am really happy that a lot of people are coming out, like just what we're doing now, to sensitize people on the importance of intellectual property and how it can actually help. It will take care of a lot of things. It will take care of youth unemployment in the country, because we have a lot of youth in the entertainment industry, in creative ideas. So when we sensitize them on the importance of intellectual property, let them know that when they protect their creative works, it will go a long way to it will put money in their pocket, because that's what everybody's looking for anyway. And it will also encourage them, because once they know that when they patent or they copyright, or copyright is automatic, a lot of people don't even know that. A lot of artists in the creative industry don't even know that automatically when you create a copyrightable work, you don't have to register it. Automatically it enjoys protection, and if you think anybody is infringing on your rights, you can actually take that person off. The notification scheme for the CAC is actually to encourage entrepreneurs that when you notify the CAC and there's an infringement of your work, that will also help you in your infringement action. It's not that you have to register your copyright. Let me know if I should continue to talk. I still have more points, but I know you will still come back to ask me more questions. So I also want to note that effective intellectual property increases funding for research and development and other innovation for the entrepreneurs in the ecosystem. Once they know that they have government backing, that once they patent and they have protection over their trademarks and their, What's going on? If you went to do the hello, please can we mute ourselves? Can you, Shukura, please can you tell everyone to mute, or you do a central muting and it will just be me and you talking?
I believe it's fine.
Hello,
now.
can you still hear me?
Yes, I can hear you.
Yeah. Okay, thank you very much. So I was saying that effective intellectual property rights increases funding for research and development and other innovation, including helping firms realize more value from innovations that are protected by intellectual property than those that are not. IPR underpins development of cultural expression and diversity, and it promotes broader dissemination of innovations through publication and licensing. So for the entrepreneurial sector of the ecosystem in Nigeria, once the young creatives, once the SMEs understand the importance of intellectual property, they know that once they have this protection, they can, for a period of time, enjoy monopoly over this work. It will encourage more entrepreneurs to invest. It will also encourage the industry to invest in the entrepreneurial sector, so that will grow the economy. Shukura, do I still have more time?
Yes, ma, you can round up now, ma. Thank you, ma.
Okay, so and I want to note that intellectual property protection helps small and medium enterprises. I want to reiterate that because they use IP more extensively in many cases than larger companies. SMEs, that is the small and medium-sized entrepreneurs that use intellectual property, report higher growth, income, and employment than those that do not. So it is important, and I'm also urging more lawyers to be interested, to be IP enthusiasts, so that we can sensitize the public, to sensitize our entrepreneurial sector, because that is what will actually help youth unemployment in the country. For people to know that, we need to really create awareness on the importance of intellectual property, but in the entrepreneurship sector, to let them know that, when they invest in research and development and they come up with an innovative work that is going to solve a technical issue in the country, they will get protection over a period of time to enjoy the monopoly and recoup their investment in their creative work. Thank you, and I hope you come back to me because I have more points to make.
All right, no problem.
Thank you for
your insightful submission. So we can actually say that the innovation in the entrepreneur system is a bit slow compared to the creative industry. Let's take a look at entertainment, for example. Growth in entertainment these days is very fast, and even though they're really not keen into their IP system, their awareness, we have series of entertainment lawyers on social media platform, and they keep talking about how creatives, musicians especially, how they can actually monetize and protect their intellectual property. But when it comes to innovation, we don't really have much awareness in these aspects. And just the way people are really creative in Nigeria, but we don't know how to protect our innovation. And that's the problem we are actually having. Protection of our innovation is important. And as Dr. Shimilore has said, we need to use the patent, industrial design, which are majorly on protection of the invention, that's the technicality and the functionality and the aesthetic. We need to use it to improve our economic development. So thank you so much for that. So we are going to move into the policy section now. We have two speakers on policy. So I'm going to start with Chineye first. So far from the discussion, it is well noted that IP can engineer business growth and sustainability. And yes, in September 2022, we had a stakeholder workshop on the validation of IP. But my question goes this to us. It doesn't end there. It doesn't end on validation. How can we implement this IP policy? So my question is, how can we implement IP policy in Nigeria so we don't keep having this policy meeting and not seeing results at the end of the day? Chineye, please, can you answer that question?
Yes, please. Good afternoon, everyone. Just a point of, still morning. I guess I'm racing ahead of time. Just a point of clarification before I respond to the question. I'm not a policy maker. It's only government. It's only government that creates policies and implements policies. Well, in Nigeria as of now. However, I am in a position to advise
speakers, but the second speaker is not available. So you just take that question while he joins us later. Thank you so much.
So anyways, I'm in a position whereby I advise governments on the creation and implementation of policies, right? So I'm an expert in the field. I have a trained public policy implementation expert. However, I support policymakers. That's just the clarification I'm trying to make. By my profession, I'm a lawyer. I have a law and consulting firm called the Firm Advice. However, we offer public policy advice and support governments in implementing. So that's just the clarification that I make. Part of the work I've done has cut across various sectors, like IP policy. We've been doing a lot of advocacy in the space for a long time. In fact, I know lawyers who were even advocating for it many years ago. However, recently, thankfully, we have a policy, even though the president is yet to assent to it, but like you said, there've been a lot of stakeholder engagements amongst other activities being done. And we all know that in Nigeria, one of the major problems that we face is the problem of implementation. We have a lot of documents, beautiful drafts and things put together, but most times the political will is lacking. Most times there's a disconnect. And in the area of IP, what I've found from experience with engaging stakeholders is that they don't see it as a priority. Sometimes they find it very technical. When you deal with the average civil servant or you deal with the average politician, for instance, they'll ask you, what is IP? It just seems so trivial. The focus mostly is on things like oil and other aspects that they think can generate money. However, we all know that we're in the fourth industrial revolution and there's a race globally, especially in the area of innovation, creativity. For instance, a lot of the investments coming into Africa now and to Nigeria are actually in the tech and digital economy. We have about 6 unicorns coming out of Nigeria at the moment. So it means that IP is quite valuable. Apart from in the area of technology, obviously we talked about music, fashion, although those areas are still evolving and we've not been able to really tap into the value and the income generation that can really come into this country, the economic diversification, foreign direct investments. I think that would just scratch the surface. A lot of the work I also do with international clients in the tech space, and from the research we've done, we found out that one of the major impediments to investment in Nigeria is the lack of a coherent IP policy. We know that counterfeiting is a big thing in Nigeria. We know that enforcement is a big thing. In fact, my firm is currently handling a landmark case in patents for furniture. We are representing one of the leading furniture and design companies in Nigeria, and they have been facing a lot of issues with IP infringements. A lot of their staff steal their drawings, steal everything, go and duplicate it, and even the company is losing lots of revenue, is losing so much. And, when we took this issue to the law enforcement, you could see that a lot of them it was almost like a laughing matter to them, like, oh, what is this? What's really this IP? Meanwhile, this company has spent a lot of money on research, spent a lot of money on the particular innovation. They have a technology that's one of a kind. They have a floating cupboard, floating beds. There's a technology that they put to make it stand behind it. And they got a utility patent and a design patent. But when we were talking to law enforcement, they didn't even know what we're talking about. They just felt like, just allow these people now to take this design and go, But we have to explain to them that if someone steals your iPhone or if someone steals 500,000 naira that you have here, imagine, 500,000 naira cash. Now people are looking for cash. You won't treat them the same way. You go and arrest the person for theft. But how come you don't place a priority? You don't place a premium on a design that people have spent millions and millions, and the company that is losing hundreds of millions, you don't see it as anything. So first and foremost, before we can implement this IP policy successfully, we need a change of mindset. We need a culture shift. We need a mindset shift among the policymakers and the law enforcement and the various arms of government to see IP as something that is valuable, to see the idea, the invention, as something that is valuable. Because as it stands now, a lot of the sectors we talk about, music, movies, tech, even agriculture, all these sectors, they're all affected by IP policy. Another thing we also have that is a major issue with implementation is that sometimes we do a lot of isomorphic mimicry. This is basically copy and paste. We look at what happens in other countries and we just want to come and put it into our own country without thinking about our own context. Nigeria has a lot of local invention. Can we really look at how we can protect our local invention? We talk about geographical indication. You have the Nsuka pepper, you have all these kilishi, you have things that are very notable to certain parts of Nigeria. Other parts of the world, like France, everybody knows champagne because of the wine. Everybody knows the chocolates that come from Switzerland and all that. Why are we not doing the same thing in this area and bringing it down to the grassroots level, the farmers, the local manufacturers? Because the theme of this event is about SMEs, right? How do we educate the people on the grassroots? And how do we help them to see that this thing actually has value? It has monetary value if it's properly protected. So there needs to be more synergy amongst the government agencies, the enforcement. They need to see it as something valuable. There needs to be a lot more education and sensitization, and I think a big part of the budget, if this next administration is very serious, should be to really strengthen our IP regime. Because when we do that, we create wealth. 130 million Nigerians are in multidimensional poverty. That means that a lot of Nigerians don't have a way of creating wealth. How you solve poverty is by creating wealth. Protecting your IP is a way of creating wealth. Because if you make a creation, an invention, you can license it. In fact, if you die, your family members can keep benefiting from that IP. That's how you create wealth. By creating, and being able to export. So let me just stop here. Thank you.
Thank you for your insight. And what she has said so far is, number one, we lack priority. We don't give intellectual property priority. And the thing is, if we haven't seen the oil, or the government haven't seen the oil in IP yet, until they see the oil in IP, that is when they start taking us seriously. Also, inclusivity. Everybody has to be inclusive. The government, the judiciary, the court, everybody, because if only the practitioners know about it, when you go to court, who will speak for your behalf? So everybody has to be included in this. Then awareness. The awareness is not going around. Every one of us needs to champion IP awareness. It shouldn't be left to only the practitioners alone. Also, IP is not limited to lawyers. Anybody can know about IP. So this awareness needs to go around, because if we keep having this policy without implementation, we are going nowhere. We just keep beating around the bush. So thank you so much for your input. I think that will be all on this session. If we have any additional comments from our speakers, you can just have for our panelists just 2 seconds to mention about it. Then we'll go to the top panel. Thank you. Dr. Shinoye, I'm sorry, Dr. Oluwasemilore, is she still here? I'm not sure.
I'm here.
Okay, Mike.
Sorry, I'm not using my video.
Okay, no problem.
Yeah, I'm not using my video because my internet is weak here. Okay. So I want to reiterate that sufficient intellectual property is key to promoting innovation. Is very, very key. Yes, we don't have much development in innovation, but we need more sensitization. We need more awareness. And once they know that, once they protect their innovations and their creativity, they have monopoly, they'll be able to recoup, their expenditures on whatever they have come up with. Once we have that, much awareness on innovation, on young entrepreneurs, a lot will happen, and that will not only help our GDP, but even our foreign investments. Thank you.
Thank you so much. Thank you, Doctor. Mr. Bolu, do you have anything to say?
Yes, just to add, I've always been an advocate of the Nigerian university having a proper intellectual property office. Now, every student that wants to conduct have the final year research should always be allowed, or should be given a system where they can check the patent information prior to search to know what exactly has been in existence. So, and such students should also have the opportunity of getting someone to patent the work or the invention, perhaps pro bono for free. That's all I would say. I wouldn't know if IP Business Capital can write this as a recommendation to perhaps our federal government. Should start looking at that. Thank you.
Thank you so much. And I'm just going to say something on that innovation you just spoke about. Most times we keep repeating what has been done, and we all know that whatever we have in the public domain cannot be patented any longer. So students or researchers will actually try and use most of the patent databases. I'm aware that most of these databases are not available. You can't access them. But currently or recently, WIPO actually partnered with the Nest Hub. So they have this, they are now a TIC center, Technology and Innovation Support Center. So you can always go to their office to check on the databases on the available patents in registration. So you can check access and know what exactly if what you want to do is patentable or not. So I move to Chinaye. Do you have anything to say?
Yes, I'll just wrap up with 2 points. The first is on capacity building, especially for those in the public service. For instance, there's something called a novelty test or a substantive test when you want to register your patent, right? If you create an invention. In Nigeria right now, it's more of a paper application. They don't actually test to see whether what you did is different from another person. And because of that, someone can just take someone's idea, steal someone's idea and rush and go and register it first. So you see a lot of passing off and a lot of IP infringement going on. So the government should take it seriously, especially if you want to really support this SME and the budding tech industry and creative industry in Nigeria, and even manufacturing and all that. You need to ensure that we employ the right people in the civil service, the right experts to be able to carry out these novelty tests. Also, the bills that are currently before the National Assembly, we must prioritize them and make sure that they are passed. Let us treat it as urgently as we treat other bills. And then finally, Africa Continental Free Trade Agreement is here, and if Nigeria doesn't position itself properly with the right laws, with the right policies in place being implemented, we'll just be a dumping ground and we'll really lose out on the race when we compare ourselves to other African countries. All right, thank you everyone, and it was a pleasure to be here.
Thank you. So we have a question in the comment section, and that question is on policy. So Chinaye, please, you'll be able to take this question for us. In the area of policy, do we have any attempts at updating current IP-related statute like the Copyright Act and Co. in the area of policy?
Yes, so a lot of stakeholders have been coming together. In fact, last year, I'm the thematic lead for innovation and intellectual property for the Nigerian Economic Summit Group, NASBA, which is the National Assembly Business Environment Roundtable. And a lot of work was done all through last year, both with us, with IP Fest, other groups, to ensure that this copyright bill passed. I don't know, someone needs to mute themselves.
Dr. Shemilore, can you please mute yourself? Thank you. Please go ahead.
Yes. So like I discussed, we tried to push it. In fact, we had a public hearing where top creative industry people, Two-Face Idibia, King of Boys, what's her name again? The Yoruba lady. In fact, the whole National Assembly was filled with entertainers. The senators were even shocked. They said, what's going on here? Because they, a lot of them, a lot of their colleagues have been dying, without getting the royalties and things that they're supposed to based on their creativity. So we really put on a very good outing, for this copyright bill, and they assured us that it was going to be passed. Unfortunately, it wasn't passed. I don't know why. And now this tenure is about to end, and there's going to be a new. So we're just hoping and praying that the next administration will pick up these bills. Both the patent bill is before the National Assembly. The copyright bill also is before the National Assembly. So we need to work on that. Even the trademark bill, all our laws need to be updated. We cannot keep relying on laws that English law that we borrowed it from, they've moved on from it a long time ago. So we must come up to date, with our legislation, and we need representatives. We need to vote in the right people in the National Assembly so that they can see these bills and prioritize it as well. Thank you.
Thank you so much. So to round up this panel session, I would like to encourage every one of us to put more into the entrepreneur industry, just like we are seeing in the entertainment industry as well. These entrepreneurs, they really don't know where to get most of this information. So the more we put out there, the more they also benefit from it. So I'm going to hand over back to Damilola. Thank you so much for having me. Is Dami in the house? I can't hear from her. Or is it from me?
Thank you, Shukurat. She'll be coming in on board soon.
Okay.
Hi, Damilola, are you in here? Dami, can you hear me? Apologies, everyone. She'll be coming back soon. I think it's a network or something.
Thank you so much, everyone. I apologize. I had some network challenges for a few minutes, and so I was thrown out of the meeting. But I do want to say a very big thank you to our panelists and, of course, our moderator for lending their thoughts to us on our last topic of discussion, which was trade and investment policies for business sustainability. Right now, we're about to do something rather unique. We're about to proceed on a short break. And I'm going to ask that you take a few minutes to stretch your feet, maybe grab a cup of coffee or drink some water or use the bathroom. But more importantly, I'm going to encourage that you get to meet other people who are a part of this conference. So you can send someone a DM. Perhaps there's someone you had always wanted to connect with and is here on the call. Just say a quick hello, get to meet someone, and take this as an opportunity for you to network. So are we game? Are we game? Would we do just that? I'm hoping to see your comments in the comment section. Are we game? I can't see any comment yet. I need to be sure that you heard me and that, of course, you're doing this with me. Beautiful, beautiful, beautiful. So let's take that 10-minute break. We'll be back at 11:30 a.m. Nigerian time to continue with the next panel session. And of course, it's back-to-back value and amazing, insightful presentations. Welcome back everyone from the short break. I do hope that you took the time to connect with someone. I know that conferences like this are always a good opportunity to get to meet new people. If this was in person, this would have been the time to exchange complimentary cards, have those quick conversations where you get to know someone and hopefully carry on the conversation from there, connecting on social media and what's not. Welcome back to, can I call it Q2 or the second half of the IP Annual Discourse. So far, we have had 2 panel sessions, and it has truly been an insightful and enlightening time. This morning, we've looked at licensing, merchandising, and partnerships in the creative industry, the opportunities and risks that come with those. We've also taken a look at trade and investment policies for business sustainability. We had a topical presentation as well, looking at intellectual property rights, foreign direct investment, and economic growth. So I want to know, are you ready for the next panel session we're going to be having? Are you ready? Are you set? Are you excited in the commodities that you're looking forward to? Are you excited? Are you looking forward to the next round of conversations that are going to take place? Please put that in the comment section. Let me know that we are good to go and continue with our conversations. Brilliant. Hello. Okay, I can see some people are still taking the time to do some networking, and I think that's absolutely brilliant of us to do that. We're moving on now to the third panel session for today. We're moving on now to the third panel session for today, which will be moderated by Mr. Eric Ntande. This panel session is exploring intellectual property insurance schemes. Exploring intellectual property insurance schemes. The session is to discuss the importance of intellectual property insurance schemes for creative projects, and of course, to explain the importance of insurance for creative and film projects. Before I bring on the moderator, I feel that the energy levels are a bit low. So I want to see emojis in the comment section, letting me know that truly we should proceed to the next conversation. I want to see you light up the comment section. Beautiful. Thank you so much, Oluwasegun. Thank you, Daniel. Yes, our moderator is ready. Super well done. Thank you very much. I'm going to be handing us over now to Mr. Eric Ntande, who's the moderator for this session. Hello, sir.
Hello, Damilola. Can you hear me?
Yes, loud and clear.
All right. Let me just turn on my video also. You would have to change the settings because okay, let me start now. Okay. Can I be seen and heard clearly by everyone in attendance?
Yes.
Okay. So can I start?
Please go ahead. Yes, sir.
All right. Okay. So good morning to all the attendees from West Africa, and good afternoon to everybody from Central Africa. This is a very unique experience for me. I think being the only, I'm not sure if I'm the only non-Nigerian amongst the speakers. So this is an extremely important opportunity for me because it allows me not only to network, but also to learn from so many different people who are as passionate about IP as I am. So as convener had already mentioned, this is panel 3. I'd like to welcome everybody. Thank you so much for staying tuned. Thank you so much for attending. And I hope so far you have learned so much. Even I have learned a lot of things that I didn't know. So this has been a very good experience for me. So panel 3 will be centered around exploring the intellectual property insurance schemes. And 2 of my speakers are people who I'm extremely honored to even be introducing. one of the speakers, I've had the opportunity to connect with her on LinkedIn. So this is a very good opportunity for me to at least be the person who assists in guiding her through educating some of our attendees, or all of our attendees rather, in order to build up their knowledge on intellectual property. So just to introduce our speakers, our first speaker is Mr. Gabriel T. Omoni. I don't know if he is available. I can see Miss Rita. Yeah, I can see her video. It's showing, but I don't know if Mr. Gabriel is on, but I'll still go ahead with introducing him. So Mr. Gabriel is an associate at Jackson AT and Edu, which is a corporate attorney. He is a corporate attorney with transactional experience in corporate advisory and commercial practice. He has also played a very important role in deploying, publishing well-researched articles, and also contributing to country comparative guides on platforms like Mondag and the International Advertising Bureau. So we are extremely privileged to have somebody of his expertise and experience joining us on this year's conference in order to educate us more on the importance of IP. Then we also have Ms. Rita Anwiri, who is a dynamic and results-driven legal professional with over a decade of experience in the field of intellectual property law and arbitration. She is the head of legal and operations at Anthill Studios, Nigeria, which is a leading media production and animation studio. She is instrumental in the establishment of the corporate governance and structure of the studio, and also she plays a key role in overseeing the studio's human resource and business operations. I'd like to thank the two speakers, and I'd like to welcome you to this year's IP Annual Discourse. I hope you are all both available.
Thank you. I think you got my surname wrong. I'm Anwara, but we get the mix. But myself and Anwari, like we always get the mix. It's fine.
Yeah, I'm sorry. And I remember I didn't ask before because I'm really particular about people's names, because I also get uncomfortable when people mispronounce it.
No
so I really apologize for that.
No worries. No worries.
All right. Okay. So I think we'll just go straight into it. As Damilola mentioned, the objective of this panel 3 is to ascertain the importance of intellectual property insurance for creative projects, as well as to discuss the salient provisions on issues on IP and IP insurance, and how IP insurance can be maximized by private business owners and governmental bodies. So my first question will go to you, Mr. Gabriel. And my first question is, okay, so we are aware with the growing trends in IP and how it's becoming a major focus, not just amongst us, the lawyers or people who are in the industry, but even just in general. So could you please share some insights on how international countries or the global world are exploring IP insurance covers in their various jurisdictions? And first, before you start, I want to ask an extra question, which is, can IP be protected by insurance? Then from there, just go through the next question that I asked.
Okay, thank you very much. And I'm happy to join this program and to be able to lend my voice to this great topic. Firstly, I think we need to understand that what is insurance? Now, insurance is a risk management tool that is adopted by businesses, adopted by individuals, so that to be able to hedge their risk, so that in case maybe where there is a risk, because of course we live in a world of uncertainties, and you cannot basically be sure something is going to happen or something is not going to happen. And that is why it is very important that you insure. Now, the common notion that we have globally is the fact that physical properties are the ones that need insurance. For example, our cars, our houses, our goods in transit, all kinds of things that we can basically see, that are things that we should insure, right? But at the same time, too, we equally need to understand that we need to start talking about intangible properties insuring intangible properties. And what are these intangible properties? Now, this is where we come to intellectual property. Now, before I go into the second leg of the question, it is equally important to understand that property, when we're talking about property, people get into this notion and argument that is intellectual property, is it really a property? Now, when you look at it from the perspective of a physical entity, then you might be carried away and you might say, oh, it's not what's being insured. But again, you want to look at in the conversation that number one, they both have almost the same rights. Now, what do I mean when I say rights? When you have your personal property, you have a land, for example, you have the benefit of being able to license to give out that land. You have an exclusive right on that on that land, and then you can give it out. You can lease it out, since it's a real property. You can lease it out. You can make money on it. And so when you bring that conversation also to intellectual property too, you can also do what? Also enjoy that same privilege. You have an exclusive right. For example, you talk about patents, you talk about copyright, you talk about trademark. These are rights. There are rights that are attached, and that is what makes it what to qualify as a property. Now, coming to your second leg of the question that talks about should intellectual property really how the global or how some other countries are adopting intellectual property insurance. Now, we want to look at some countries like, okay, let's go to say like United Kingdom, for example. Now, they have what is called an IP insurance, and there are different legs of IP insurance. For example, they have what is called the opinion-only insurance. Now, what this does is that it helps business, it helps SMEs, so that when there is an issue maybe surrounding their IP, it covers this opinion-only insurance covers the cost of getting an opinion from an attorney. So you don't have to dip into your the revenue of the company, of the business, of the entity. Rather, you just, because you'll be paying your premiums regularly, right? And then you just get to pay. And then also too, you have the offensive, like the one you use, maybe somebody's thinking and you want to challenge that infringement. They also have the defensive. You also are the one that you also used to defend. And even if you go to Australia too, you find that even IP insurance also too is equally applicable too. And even if you go to Japan, so global, these developed countries, they are beginning to see that it's not just enough that we have IPs, but also too, we must put in some risk management too, so that it can be able to protect the IP creators. Thank you very much.
Okay, so before you end, Mr. Gabriel, I've noticed that even as much as, yes, this conversation is centered around the global results that different countries are taking, but let's say in Africa, for example, are there any countries that you've identified that you can point out to say, okay, these African countries that are at least taking major strides in ensuring that holders of IP assets can enjoy proper insurance protection and enjoy the benefits that come with doing their best to capitalize from their intellectual property?
Okay, thank you. During the course of my research, I wasn't able to get any African country. I mean, there might be some, but I'm not aware of any African country that has IP insurance.
Okay.
Thank you.
Okay, so this, I would say this is a big wake-up call to Africa as a continent, because I feel we, even as much as we are looking at the global or the world international as examples, it would be really good for us to be able to point out our fellow African countries who are saying, okay, this country is making these strides and these type of innovations in order to improve IP protection through insurance. So it's been a really insightful talk. Thank you so much, Mr. Gabriel. And as we proceed with the discussion of panel 3, I'd like to now forward my first question to Ms. Rita, which is, could you explain the concept of errors and omissions insurance that are experienced in insurance for creatives, and why is it important that these errors and omissions should be identified, and how best can whatever problems that arise from such issues be properly resolved by IP asset holders?
Okay, can you hear me very well? Am I audible?
Yes, I can.
Great.
Yes, you are.
Again, I'm really glad to be here and to share my knowledge. So as far as errors and omissions insurance are concerned, when it deals with, I'll speak on filmmaking because that's really my area of expertise, right?
Okay.
As far as errors and omissions concerned, it's really the errors and the omissions that can actually occur is when, say, for example, you know what, let me backtrack a bit. Now, the only reason most people get errors and omission insurance is when the film is going to get distributed, right? Is if it's going to get distributed, how large or the coverage of the distribution. So what this does is it helps to mitigate any risk or any form of mitigate any claim. You know, basically, if you're like a production company where I work, if we're going to put out a movie, obviously like in the cinemas or on streaming platforms, and it's going to have like a worldwide coverage. Now, if anyone comes up with a claim, a copyright claim of any sort, what this does is it gives us cover up to an extent where every litigation every cost associated with that claim is taken care of by the insurance company. This way, we do not get, we don't get burnt so much, you know, in terms of the financial implication of it. You know, IP is very valuable. As valuable as it is, it can also, the claim comes up, it can also drain every single money and even more that you have made from that film or project. Now, what is errors, the kind of errors and omissions that can happen that would warrant you taking an insurance out is, again, a copyright claim. A situation where your film, the script, someone else somewhere says, oh, this story is something that you heard from me. This story is my idea, it's not yours. What that means is when that kind of claim comes up, the errors and omission policy kicks in, right? So you let your insurance company know, and then they just swoop in to make sure that they are covering every cost. Now, that's one of the things that can come up. That's mostly the copyright claims, right? For the music or for the screenwriting, maybe just a portion of it, or maybe there was a logo or something that was used in your film that shouldn't have been used for fair competition. I'll give a typical example, one that is really, really out there. Black October, we all know the issue happening with Linda Ikeji and the family. Now that's the privacy rights.
Yes,
this family have come to say, look, you can't put this out there. Now, I want to believe that a movie of that magnitude, she definitely should have had proper counsel, and that proper counsel should have told her, look, if you're going to put this out there, you should get an errors and omission in case, because it's a very controversial topic.
Yes.
That's one of the things that's one of the reasons why you want to get an errors and omissions in insurance. Once you're going to have a very controversial script, that you know that, look, somebody can come out and say you don't have a right to do this. So it gives you some kind of confidence that it doesn't matter what happens, I'm going to still be standing after all this is done. So if she didn't right to privacy, you're saying you can't. The only reason why I want to believe that movie is still on a streaming platform is because there's an error and omission insurance backing it. Do you understand? That would take care of any litigation cost. So these are the kind of things that may come up for you to even take an errors and omission insurance in the first place. I don't know if I was able to answer your question.
No, you have. Thank you so much. Before I go into the second question, I think I would like to go back to the same question that I had asked Mr. Gabriel, because I like how you mentioned that there's various insurance covers and policies that you implement and provide in trying to protect the work that you put out, especially in film. So I would like to find out, are some of the insurance companies that you engage, are they Nigerian companies, or you mainly work with international companies?
So one of the good things about, first of all, let me say this. In Nigeria, and I'm saying this, I stand to be corrected if anybody has a correction, but in Nigeria, when it was time to have this errors and omissions insurance at the beginning stage, a lot of the insurance companies did not know what it was. They were quite lost. Then when we finally found one, so we had to get a broker. So the reason why we got a broker is, and that's like, I believe is your best bet, is that what a broker does for you is they go out and they find the best possible deal, right? If you in getting this insurance, it depends in terms of are you using a foreign insurance company or local insurance company. It depends on the coverage of the distribution. If you're having it's going to be just shown locally, only in the cinemas in Nigeria, only on streaming platforms that are limited to your local sphere, then yes, you can use a local insurance company. But one of the things that I think that a couple of insurance companies offer, like the ones that we use, what they offer is you bring it to them. They liaise with, they have insurance company, they have like their circle, permit me to use that, and they liaise with those other people outside the country. They're able to give the cover with the across a certain level. So you have the ones that would reach out to those in the UK and the ones in the US. Can you provide cover all the way to Australia? Can you provide cover all the way to South Africa? Can you provide cover all? So it depends. Now, a lot of the times, because the IP laws in these various places, they differ. You know, they're always different. The laws are always different. So the insurance company looks at the law there and what the claims could possibly go up to say, okay, yes, we can cover, or no, we can't cover. You understand? It's not, there's no clear-cut way, but the only way you can get what you want is you have to know the scope of the coverage. Is it worldwide? Is it local? Even if it's worldwide, at what location will this film be airing at?
Okay.
Yes.
No, thank you so much. Before I get into the second question, I think you've said something that's made me remember some of the things that Mr. Gabriel had mentioned, especially on the opinion-only insurance. He had mentioned how it's sort of specifically catered to SMEs. So based on everything that Ms. Rita has said, Mr. Gabriel, what advice would you give to small medium enterprises around Africa that are looking to maximize the monetary value of some of their intellectual property creations? What type of policies would you advise, based of course on the research that you've done? What kind of policies or what or steps do you suggest that they should take in order to properly protect their work? Just please be as quick as possible, as we are short on time, so that I can proceed to the Ms. Rita's second question.
Just like the focus is on SMEs, right? So I think the first thing that we need to do is that first we need to understand that insurance, as I said, is a very potent weapon that can be used to be able to hedge against risk. And one thing is, I think, of course, there are different forms of insurance, especially for IP. There's the commercial general one, just like the one Twitter has said. There is offensive insurance, there is defensive insurance, and then there is one that deals with directors and officials coverage. I mean, in all these things, one thing that's very important is for SMEs, I think they want to protect their brand. And if you want to protect your brand, I think it's very important that you take either an offensive or a defensive coverage. Now, an offensive is you use that to be able to enforce your rights. Now, it is very important. I mean, it's so very difficult to pinpoint the best coverage for them, right? And the reason is because pinpointing because if you want to enforce, then you take an enforcement coverage. And if you want to defend, you take a defensive coverage. Now, if you are enforcing, somebody has infringed your right, depending on the kind of right. It can be trade secrets, it can be trademark, it can be design, it can be copyright, anything whatsoever. Now, basically what you do is that if you take an enforcement coverage, the one that basically covers enforcement, that means that when it is time for you to enforce your rights, you can easily approach the insurance company and tell them that an infringement has taken place, and now I'm calling this company to come and take over and then pay every fee that is necessary for these rights to be enforced. And if they're taking a defensive coverage, I mean, so it depends. A company might want to push you to a very difficult point where you have to surrender your IP rights. Now, what do I mean by this? Because IP rights is something that's very essential for you, for your growth, for your business. And a company might just feel like, this is a small player, and we can bully them into submission of it. So an SME can take a defensive coverage, whereby when they are sued, even though the right belongs to them, but because they want to be paid, can take a defensive coverage. And basically what the defensive coverage does is that it's when they are being sued, they will approach the insurance company, and the insurance company takes over, and then to be able to do what? To be able to pay for the cost of it. I mean, all these things, it just depends on the business strategy and the business plan of that company. Do you want to hedge against liability? Do you want to hedge against damages, potential damages that may come up? Then it depends on the one you want to take. But everything just again boils down to what you want to do, the business, and what you think is probable that can happen to your business and make it to be able to scale eventually.
Okay, Gabriel, thank you so much. So based on what you have said, which would you advise would be the best step that SMEs can take? Should it be the offensive coverage or the defensive coverage?
Okay, yeah, as I said it depends on the business model. Now, but I think the offensive model most likely looks like the best for them because I mean, it's infringements can take place almost at any point in time. And so taking an offensive coverage might actually be the best. But again, you want to factor in some standards that I said, there might be an attempt to bully you to take up some things and then you might want to. So, but most likely the offensive coverage to me looks like the best thing for business enterprise.
Okay, thank you so much, Gabriel. So moving on, Ms. Rita, the second question of our panel discussion is directed to you. And this question is, what other kinds of insurance covers can creatives explore to protect or have some cover over their intellectual property?
Okay, just like Gabriel had said, you have the offensive and the defensive, right?
Yes.
Because again, I'm in the filmmaking space, aside the errors and omission, can you hear me?
Yes, I can hear you.
I can't say there's a clear cut, but what I can say is you can, one of the things I've noticed that we do with insurance companies, that screenwriters particularly do with insurance companies is this: you have the conversation and say, okay, I would like to cover X, Y, Z. It depends on the term or the kind of cover you want, what kind of protection you're trying to get. So you can have a mixture of both defensive and offensive together. You can have the one that says, it's just in terms of like E&O is majorly defensive, right? But you can go further to say, even if I'm doing an E&O, would like to have extra cover for this, for this, for this, for this. So I would say, particularly because I work with screenwriters a lot, one of the ones I would ask them to get a combination of offensive and defensive, right? Just for your screenplay, get a combination of both. What that means is it's going to give you leverage and confidence to negotiate higher for your work, especially when you're bringing that work to a production company. Now, because the production company goes as far as the E&O, the E&O is to protect the production company, not the screenwriter. In every screenwriting agreement, there's a portion that says, look, you're going to be, you agree that this work is originally yours, right? And you're going to be liable if somebody comes and says, oh, this work belongs to me. So I, as the production house, because I'm taking this thing I'm taking this film to streaming platforms, I'm going to take an E&O. But because you're a screenwriter, before I pay attention to you and you tell me, look, I have this script and I've gone as far as taking out an offensive and defensive
both are offensive
insurance.
Yeah.
Sorry about that. It gives me, the production company, confidence that yes, you have taken this measure. That means you are very, very confident that it belongs to you. So there's that helps to mitigate how much premium I'm going to pay on my E&O.
Exactly.
So if I have that, those are the stages that helps to even build up my own confidence when I'm speaking to my insurance company about taking out an E&O and telling you, look, I'm not susceptible to a copyright claim. So my premium goes lower, right? That's the negotiation part. So I'll say for creatives, whether you're a songwriter, you are a writer, whether you are a screenwriter, whether you are whatever it is that we can put a figure on intellectual property, take a combination of offensive and defensive. Because what that means, you can go after someone who has tried to infringe on your own rights. At the same time, you can defend yourself without the hole that the litigation cost or whatever it is would bore in your pocket. So that's basically my advice. Take both, a combination of both.
Okay.
Give you
Thank you so much. Okay, thank you so much, Rita. Before I get into the question and answer session, this question is directed to both you and Mr. Gabriel, seeing as how we're focusing on being or providing information that will allow not only SMEs, but any small creative houses on the come up, be it creatives who are working as individuals, whether they are individual songwriters or filmmakers. What do you suggest, or rather, how do you say, what things do you think need to be done in order to create more awareness on the issue of insurance? Because this is something that even I'll admit I didn't know about. Something that more of these creatives, what needs to be done in order to ensure that more creatives know that, okay, indeed, they can be able to protect their IP through insurance, and also there are these offensive and defensive combinations that are available to them. So being the custodians of such knowledge as lawyers and researchers and people in this field, what more do you think needs to be done by people such as us in order to increase awareness of this kind of protection that creatives can enjoy?
Okay, do you want me to go for?
Yes, please, you can go first, Mr. Gabriel.
Okay, so for me, I think everything boils down to first, we need to, programs like this are very good avenues, because basically it tends to explain, it tends to serve as an eye-opener to SMEs, right? To be able to know what is at risk. And again, we need to understand that tangible properties like IPs, they are more or less like the core of most businesses, most especially in this 21st century. IP is beginning to play a part because most businesses now, this is what is like their stock in trade. And so the moment we need to first understand that there need to be an understanding that there is a risk where there is misappropriation. There is a risk whereby they are unable to defend their IP. So if that is first established, then again, the next thing is that the insurance company out there too, they equally need to make this an option. Let it be known that, okay, we can protect, we have products that can protect SMEs, that can give them a bit of comfort, that can help them, that can hedge their risk in case there are misappropriation. And again, I think the National Insurance Commission and everyone that needs to roll out IP-specific insurance, so that at least when we have that, insurance companies can be able to give out different, can be able to roll out different products that are IP insurance related, and then SMEs can begin to see that, okay, we need this, we want, we need this, we need to put this as part of the things that can help our businesses to be able to grow. And at the same time, too, we only need to understand, yes, there are a lot of capital development that will also be needed, and I think the government should be very much invested in that, because you can't just do IP insurance without understanding what is IP. You can't just give it to anybody out on the streets out there and just say, oh, we are rolling out.
Okay, thank you so much, Gabriel.
Yeah, thank you so much.
All right. So Rita, could you please just close on what you think needs to be done in order to increase awareness on this very important topic?
I think that first of all, as lawyers, hello, can you hear me?
Yes, I can hear you.
Okay, as lawyers, it is very important that we personally expand our knowledge base, because a lot of the times we don't know that these things exist. And when we expand our knowledge base, we are able to advise properly, like Gabriel had said. we're able to advise accurately. Now, I remember a friend of mine asked recently that, is there any institutionalized act that basically gives power for or gives rise to IP insurance? And I said, no, we don't have it. And that's why insurance companies will know about these insurance policies. Also, it'll be good for creatives to also come together in terms of the policies. I think we had a policymaker on the last panel session. It will be good for these policymakers to actually take this up and like champion the cause, because it's very, very important. And most importantly, lawyers need to accept or be open enough to say, I don't know something, and reach out to their colleagues to say, can you enlighten me on this? As opposed to just going ahead and drafting regular contracts and just doing just anything, because I have severally had a lot of times where lawyers are trying to be, I'm a lawyer, I know it all. And it is okay to say, I don't know this, and reach out to the lawyer on the other side to say, okay, I see that this is there. Can you do like an explanation or something?
Okay.
There's no shame in that. There's literally no shame in that. If you don't understand it, reach out. That's what I'll say. And I'll say for creatives, it's very important that we live in a society where people don't appreciate taxes, let alone insurance.
Exactly.
They don't appreciate it. They don't understand. But I feel like if insurance companies agree, like for those creatives, for screenwriters, for SMEs, because of the term of the insurance policy, usually was just 1 year and you have to pay over again. They could come up with a style that says this is for a short term. This policy, when you pay for it, it covers for 10 years. It would encourage people to actually go for this insurance. As opposed, because the premium on, I would tell you sincerely, the premium on E&O is a lot. That's why I'd say it's usually if your movie or so is getting distributed. The coverage, because of the risk that could come up when there's a claim, because that's as valuable as the IP is, it can drain you. So if they come up with a form of insurance policy cover tenure that is beyond a year, a screenwriter can easily afford a premium that's going to cover 10 years and be fine with it, and say, okay, next, and that 10 years I could pay another premium. Those are the things I think that things that could be put in place for like to help in terms of IP insurance and creative industry.
Okay. Okay, Rita, thank you so much. I think in the interest of time, let's just drive straight into the questions. So we have a question from Kefas Glavi, and this is a question that will be directed to both speakers. Is there any mechanism to protect the IP holder from exploitation in terms of the cost of the insurance? I think, Ms. Rita, you can go first since you're already.
I didn't get the question.
It says, is there any mechanism to protect the IP holder from exploitation in terms of the cost of the insurance?
Okay, so that sincerely, I wouldn't say there's any mechanism, but I'd say if you've done, there are a number of things that would arise in terms of how much you're going to pay as a premium for the insurance to the insurance company, right? One is the, again, I said the coverage, the budget of your film, the budget of whatever it is, the budget, what's the value you place on it? If the coverage is worldwide, and you want a coverage that's going to cover, that's going to take, if there's a claim and it can pay up to $250,000 claim, then the typical IP premium is 1% of the value of the cover. It's usually 1%. So the only way you can negotiate that down is, are you susceptible to IP claims? You're going to look at back records. Have you had previous IP claims? No, I haven't. I have registered this. I've gone forward to get a copyright certification for this work. I have gone. There's like the budget. How much is this film going to cost on a normal day? How much is it? Is it a 100 million naira film or is it a 200 million naira film? Then on what platforms is it going to? If it's going to Amazon like ours, or it's going to Netflix, that's worldwide, right? So you can negotiate. You can negotiate. That's the good part. That's why I always advise to get a broker. Don't do this yourself. get a broker who's going to go around and help you.
That's very true.
Those people would have your interest at heart and get you the best deals. So when you are going to that table, when you're signing dotted lines, you know that this is the best figure that I can get. I'm not being exploited by an insurance company. I'm not, I'm paying the right premium for this. Hope I was able to answer the question.
Okay, now I'm sure you have. And please, if the people who have asked the question, if you feel the question has not been answered, please feel free, as we are still within the time. Then, Gabriel, I think you can close and just add on your thoughts also on the same question as to what mechanisms are available to protect IP holders from exploitation in terms of insurance.
Okay, yeah, so when you want to protect against exploitation, I think one of those things again that you need to factor in is that there must be proper valuation, right? You want to properly evaluate your IP so that you don't get to pay more for what's there should be a proper valuation of IP assets. So if your IP asset is properly valuated, the risks are properly valuated and everything, then that is the way by which you can be able to pay the barest minimum and while getting highest benefits. So I think that's just the only way, because insurance again, something that is a contingent, right? And insurance company wants to protect themselves, and you want to protect yourself as well too. So properly valuing your IP is very essential.
That's very okay. Now, thank you so much to the both of you. I feel you should really connect. If you haven't connected already, please share knowledge, because this is a very unique topic. I think it's the first of its kind that I've ever seen being discussed on such a platform. So thank you so much for the contributions that you have both made. I really hope everybody in attendance has learned something. I know I have. And I think I can allow for one more question if there's anybody who feels they have something that they're still not clear on before I pass it on to the main moderator of this year's conference. I don't know if there'll be any further questions. Okay, I think it's safe to say that everybody has at least learned something. And like I've emphasized, please, Gabriel and Rita, you two need to connect. If you haven't already, please get through.
Okay, I think someone is raising up. I think someone is raising up.
Okay, please.
Okay, good day everyone. My name is Rosemont, and mine is not much of a question, but it's actually a comment. And I just want to say that I think this topic was incredibly insightful, and I really learned a lot. Like you rightly mentioned, I think conversations like this are very, very good. And I think speakers did real justice to the conversation. I just want to say thank you to them. I really learned a lot. And I also thank the organizers of this event. So it's great being here. Thank you.
Okay. Thank you so much, Rosemont. Thank you for attending. Thank you for contributing. And thank you so much to IP Business Capital for providing this amazing platform that has allowed us to learn so much, not only just about intellectual property, but as well as the insurance protections and covers that are available to holders of IP assets. So I think at this point, I'd like to thank both Mr. Gabriel and Ms. Rita. Thank you so much for taking the time out of your busy schedules to educate us on this very insightful topic. And I'll hand over now to Ms. Damilola. Thank you so much.
Thank you
for having us.
Thank you very much.
Thank you very much, Rita Anwara and Omoni. Thank you very much for sharing with us today. That truly was very insightful for me to see how insurance can definitely help ensure that intellectual property goes on well, intellectual property protection rather goes on well. Thank you very much for sharing your thoughts with us on the panel session. I want to hear from everyone as well, your own feedback, one word to describe what this last session was like. Just one word from you, one word from everybody. Tell me, what was it like for you listening to our panelists, and of course, the moderator share on the topic. Thank you very much, Mr. Aluko. Sefa says very educative, Rosemont enjoyable and instructional. Definitely instructional. Towards the end, that contribution on IP valuation, how that can help us boost policy regime for getting insurance for IP was definitely very, very instructional for me as well. Thank you very much once again to our moderator, and our panelists. We're moving on now to something rather interesting. We know that this conference, the IP Annual Discourse, is brought to us by IP Business Capital, but not many of us are very much familiar with the brand and what it does. So we're going to have the convener of the conference, Ms. Ololade Oloninyo, who's also the founder of IP Business Capital, speak to us for a few minutes on what that is and let us know possibly how we can come on board. Can we please give her a round of applause as she takes the virtual stage? Welcome, welcome.
Good afternoon, everybody. Thank you so much for joining us. Can you hear me?
Yes, loud and clear.
Awesome, awesome. Apologies for my voice. I think I'm a bit tired. Okay, so I'll just get right into it. I'll be talking a bit about IP Business Capital, and like Damilola mentioned before now, this annual conference was brought to us by IP Business Capital. Okay, so I'll just go right into what we're about and what we're doing, right, and how people can join us to drive the vision of IP Business Capital forward, right? So IP Business Capital is a business advisory firm, and we are providing cutting-edge IP solutions to African institutions, right? So we help C-suite leaders, media houses, creatives, corporate institutions to value and protect IP assets that contributes to business growth. I'm very, very glad that the last panel, section spoke about the importance of IP brokerage services. Those things exist. I mean, we don't hear about it here in this part of the world, but those things exist in the European continent. They exist in, international markets, right? So there's something that is known as valuation and protection of intellectual property assets. So you have to value. When you value, then you know how much premium you should place on those IP assets so that you can protect them. So we are about that. We are about, the valuation and protection of IP assets that contributes to business growth, right? So part of our mission is to become an enabler for inclusive IP development amongst small and medium scale enterprises in Africa, right? We know that, and that's why we are championing the cause in Africa, right? We know that when you're talking about international markets, a lot is happening with licensing, a lot is happening with franchising. I think there was a report done by the African Import and Export Bank on why we don't have much franchise happening across Africa. But other governments, institutions, other international markets are thriving on their intellectual property by licensing, franchising, and there is a lot going on within those continents on a grassroots level, right? So part of our mission is to enable this inclusive IP development amongst the small and medium scale enterprises in Africa. We are really focused on empowering African entrepreneurs to create tangible value from their intellectual property. So of course, beyond just entertainment, there are other markets that we can plug into. There's manufacturing, there's fashion, there is tech, there's innovation, and the interesting thing about IP is that it cuts across all sectors. We just need to begin to see the value in our intellectual property. And I keep saying it that the same way you have a property that is you have a real estate property that you can value, that you can protect with your registered rights at the landmark at the land registry, that you can do a proper estimation of how much it's worth, that you can lease it out, right? That you can sell it. It's the same way your IP is also a property that can be sold, that can be licensed, that can be leased out. You can get ownership rights over it. And so we need to begin this conversation where everybody is carried along on how important IP is. And then we start to talk about it in such a way that even other countries can see that, oh, wow, these guys are so much they are investing in the IP system, right? And is now is the right time for us to get into their markets and start to exploit, you know, their intellectual property with them, and start to become, and let us become a partner, right, in terms of driving IP development within the African continent. So that's what we are about. We are leaving the regime of just what's it called, of just protection. We are going into deeper things, licensing. How can we enforce IP rights? How can we, you know, all these things are part of what we are doing in terms of empowering African entrepreneurs to create tangible value from their intellectual property, right? So of course, our website is ipbusinesscapital.org. I don't know if Sharon on the call, that will put in the chat box at the moment. Sharon, please put that in the chat box. Our website, if you'd like to know more about what we do and what we are about, you can check out our website, I mean. Okay, yeah, so let me see if Sharon has put that in the chat box. Awesome. Oh, Dami has helped out. Awesome. Thank you, Dami. So yeah, moving on, yeah, of course, like I mentioned before, we provide IP solutions, right? From protection from IP advisory to IP consulting to protection, to valuation, right? And even helping you to identify the right IP in your business that can contribute to business growth as well. So if you require any of our services, right, you can send an email to info@ipbusinesscapital.org. So that's our official email. You can also send an email to that email account, where we'll reach out to you back definitely. So yeah, just beyond empowering African entrepreneurs and beyond corporate IP advisory solutions, we are also championing the cause of helping creatives, right? African creatives now, especially African storytellers, to develop, you know, hands-on practical skills to grow their capacity to tell authentic African stories. Remember that I mentioned before now that we are about the African continent, right? So we launched a creative hub that is focused on helping storytellers, African storytellers, to tell authentic African stories that travel around the globe. So we actually have a creative platform for that, but the thing is that it's narrowed down to certain kinds of creatives. So if you're in the film industry, if you are a screenwriter, if you are a creative producer, if you're a filmmaker, right? So it's narrowed down to film and television. So if you're within those spaces, I mean, this is an opportunity for you to be a part of the African Creative Hub. As a member of the hub, you have access to entertainment events, right? You have access to our exclusive masterclasses on screenwriting and filmmaking, right? Of course, you would also have access to these things free. I mean, who doesn't like free things? Then you have access to, there'll be opportunities to collaborate with people within the hub as well. So networking opportunities, collaboration opportunities. We understand that the creative industry is talent driven. And for you to make a project worthwhile, you need hands-on people, you need talent, you need people on your team, you need people to help you. So collaboration is very critical in the creative industry. And that's why we decided to put this platform together. So if you're looking to be a part of this platform, it's free, right? And our events and our seminars are going to be exclusive, right, to members of the hub. If you're looking forward to be a part of this platform, please join us. And there's a link to join the platform. Yeah, that link we put in the chat box right away. It's a Google form. So if you'd like to be a part of us, please fill that form and we will get back to you, right? We are also open to sponsorships and partnerships, right? For our initiatives. If you like to partner with us, if you like to sponsor our work, please send an email to info@ipbusinesscapital.org. We would definitely reach out to you. Let me confirm if those things are already in the chat box. Sharon, are those things in the chat box? The links? Dami, please, could you help me post the link in the chat box? Awesome, thank you. Okay, yes, so the link to join the Creative Hub will be posted soon. Then if you like to partner with us, like I mentioned before, you can also send us an email at info@ipbusinesscapital.org. We're going to reach out to you as we are currently looking out for partners and sponsors for our projects. Yeah, so moving on. We are also looking for young and vibrant IP enthusiasts, to join our team. We have work to do, and we'll be glad to have people join us on this journey as we journey to improve the IP system in Nigeria and also in Africa, right? If you would like to be a part of our team, thank you very much, Dami. If you'd like to be a part of our team, please, there's a link that we put in the chat box at the moment, right? So just click on that link and register your interest to be part of our team. If you have registered before now, no worries. After the conference, we're going to reach out to you and gather all the details and then reach out to you and have you join us. Okay, so that's a call for volunteers. If you'd like to be part of the work that we're doing, please just register your interest with the link and then we'll reach out to you. Okay, so the last but not the least, we have what is known as the Young Professionals Program. Awesome, awesome. We have what is known as the Young Professionals Program, right? So that program is a program for young Africans looking to build careers in the field of intellectual property management. The objective of the program is to bridge the skill and knowledge gap required to develop the intellectual property market in Africa. Whether we like it or not, in the next coming years, we would see more and more of merchandising. I like the panel conversation along those lines. We will see more of licensing. We will see more of technology transfer. There will be more of manufacturing of new products. And so we need capacity building initiatives to bridge this knowledge gap, right? So that we can have an equipped talent force, right? That will go right there and provide required IP solutions to these emerging markets. And that's the reason why we are having this program. It's coming up soon, right? And we are about mentoring and training young IP professionals across Africa. That's what we're about. So it's a program for young Africans looking to build and intensify their knowledge in the field of IP management. If you would like to register to be a part of this course, just click on the link. Apologies, we have many links during this section. So just pick out the ones that you are interested in, right? And just click on the link, register your interest so that we can know how many people we should actually prepare for when working on this project, right? So get in, register your interests for the Young Professionals Program. We are coming with something big and huge, right? So please register your interest and ensure that you're keeping tabs on our work. Follow us on social media, so you can keep tabs, and so when there's an opportunity, you can always take advantage of the opportunity. Right. I've said a whole lot. Yes, I've said a whole lot. So I mean, go through the links once again. If you find anyone interesting to you, please register your interest. And I really want to say a big thank you to everybody who has joined us today. You've made this a success, right? Both my team members, the distinguished speakers, co-hosts, moderators, panelists, and even you, the participants. I mean, you made this a success. So I really want to say thank you to everybody. Thank you so much. And of course, the discourse is on. I'll be handing over to Dami. Oh, there's one more thing just before we just before we go into the discourse as well. We'll be having a product showcase, right? So I'm going to be handing over to Dami. And once again, I say thank you all for being a part of this discourse. Enjoy the rest of the discourse. Thank you.
Thank you so much, Laladi, for sharing. There's definitely a whole lot that has to be done. And I'm going to say to everyone that is a part of the call, please join us and get the work done. There's a lot of work that has to be done in this space, especially in Africa. If you listen to the first topical discussion, those stats were not in favor of Africa, in favor of Nigeria. And I believe that if every one of us here on the call can join forces, something formidable can be born out of it. Right now, we're going to go into a product showcase. We're going to be looking at some of the people that have supported the conference, and we're just going to highlight some of their products, appreciate them, and of course, invite you to be a part of what they are doing as well, because definitely they are going to be very beneficial to you. I apologize for that, some technical hitch, but I would still go on with the product showcase. Please kindly confirm if you can see me and if you can hear me, and we're still all together in the IP Annual Discourse 2023. Please confirm in the comment section that you can see me and that you can hear me, and we're still here together in the IP Annual Discourse 2023. Please let me know. I have a bit of the network issue here, so I want to know that you can still see me and hear me before I continue. Yes, amazing. Thank you very, very much. The first thing that we're going to showcase today is a book by the convener of the conference, Ms. Ololade Oloniyo. The book is called How to Profit from Your Intellectual Property. Ololade, if you could please help me with a flyer showing the book cover, I'll greatly appreciate that right now. The book is a premium handbook for creative entrepreneurs and tech founders. It provides practical answers to questions that creatives, entrepreneurs, and tech founders have about intellectual property. You would definitely agree with me that we need intellectual property education if we're going to hit those milestones and those marks that we hope to hit here in Africa and of course in Nigeria. So this book is one you should get. It explains the fundamentals of intellectual property. It also helps entrepreneurs to identify existing intellectual property in their businesses. The book also shows tactics on how to skillfully turn your intellectual property into a financial resource that brings money back into the business. The book also features major lessons and key takeaways for creative entrepreneurs and tech founders who want to make profit from their intellectual property. This book goes for a giveaway prize of 3,500 Naira. If you would love to get a copy of the book, please indicate in the chat box. I'm sure that Lorade will get across to you so you can purchase your own copy of the book. Still on books, one of our keynote speakers, we will get to hear her in a few minutes, is part of a firm, OAL, that's the Olisa Agbakoba Legal. And there's a book from them called Set Guide on Entertainment Law. The OAL Set Guide on Entertainment Law is a friendly and easy to read study guidebook for people at all levels interested in how the entertainment industry in Nigeria works. It covers broad topics in the entertainment, film, and music industries. And what it does is it presents a unique overview of the artistic, business, and legal aspects of the entertainment industry. You would agree with me that entertainment, creativity is the new oil, and it's definitely going to be, if it already isn't, one of the main drivers of Nigeria's economy. The book is organized into 20 easily digestible chapters, focusing on film, television, book publishing, music, visual arts, and image rights. Within those categories, they have topics such as agents and managers, licensing, financing, to name a few. By the end of reading the book, here's what's going to happen for you. You would acquire a well-rounded understanding of major topics in the Nigerian and, of course, the global entertainment scene. This book is priced at 4,000 Naira, the OAL Set Guide on Entertainment Law. And of course, if you'd like to get a copy, just indicate in the chat section. We would get one across to you. The book is priced at 4,000 Naira. We have another book, The A to Z of Sports Law and Business. The A to Z of Sports Law and Business. It's a comprehensive and bite-sized industry guidebook for lawyers and non-lawyers on all the major hot topics that you need to be aware of in the sporting industry. Now, each alphabet covers a topic in the sports industry. Oh, thank you very much. We have, that's the OOL Set Guide to Entertainment Law showing there on the screen. So you know what it looks like and of course, what to expect when you get this. Now back to the A to Z of sports law and business. This book is a must-have for anyone that wants to have a 360-degree view of all you need to know about the sports industry. There are 23 easy to read and concise chapters, and they tackle major issues in the sporting industry, such as sports contracts, sports dispute resolution, intellectual property rights, stadium naming rights, esports, to name a few. By the end of reading the A to Z of sports law and business, you would definitely have a better and well-rounded understanding of major topics in the Nigerian and in the global sports industry. This book goes for 2,500 Naira, and it's definitely a must-have for any IP enthusiast or any sports law enthusiast. I'd also like to bring to your notice the IP radio platform, the IP radio platform. It's a global online hub and meeting point for intellectual property professionals and stakeholders. Now, this platform would highlight news, videos, trends, conferences, trainings, podcasts, live broadcasts, and other materials and books that have to do strictly with intellectual property. So that's the IP radio platform. If you want to get on the radio, you obviously have reason to expand your knowledge base on intellectual property. Simply head onto their website, www.ipradiodigital.com.ng, That's ipradiodigital.com.ng. And I know that you definitely would get lots of information from them and value for your time by engaging with the various resources that are available on that platform. Right now, I'm going to be sharing my screen to show us the next product showcase. Well, in this case, more accurately, a service showcase. It appears to be some technical hitches, but before that comes on, Lade, could you please kindly share the flyers from your end?
Oh yes, sure, very soon. Just a few minutes.
Welcome, learned friends, to the Thinking Test House.
Happy birthday to you. Ladies and gentlemen, welcome, learned friends, to the Literally Yes Hangout. So this is the part where you applaud, you show your excitement. Thank you. My name is Damilola Busaro. I'm honored to be the host of today's keynote speaker. Ladies and gentlemen, please with a warm applause, join me to welcome Mazmi Afam Hussein. Welcome, Mr. Henry. Happy birthday to you. So we don't need to ask how old are you.
Thank you very much, everyone. So I said the last one was a service showcase. I'm Damilola Busari, and I'm honored to have been the host for the IP Annual Discourse. I am a lawyer and a compare. I'm your energetic, eloquent, elegant, and experienced compare. And if you have any events that you'd love to work with me on in the year 2023 and beyond, you can simply shoot me an email to damispeaks@damibusari.com. That's Dami, D-A-M-I, speaks @Dami busari.com. Thank you very much to everyone who has been a part of our product showcase in the last couple of minutes. And of course, the information that we have given about ensuring that you can come on board to any of the platforms that the IP Business Capital has. We're going to be moving on right away to the next set of panel discussions. And you would agree with me that the first set that we have had have been very enlightening, very, very informative, very, very insightful. And I know that this next set would definitely be that and much more. So I would love to get your feedback. Are you ready? Are you ready for the next set of panel discussions that we are about to have? We're going to have panel discussions. We're going to have a topical presentation, and we're also going to have keynote speeches. We're also going to have keynote speeches. I want to know from you, are you ready for what we still have coming for you? Let me see your comments quickly in the comment section. Are you ready? Are you set to go with us for the rest of the ride? I can't see any comments yet. I can't see any comments yet. I'm not sure whether we should ask our distinguished panelists to still continue on the ride with us. Are you good to go? I need to see it. Yes, we are ready. Amazing, amazing. So we're all on the same page together. We're ready to have the next set of insightful, engaging, enlightening conversations. I'm super glad to see that we're all on the same page. The next panel session that we have right now, we're going to be looking at the creation of specialized courts for the enforcement of intellectual property rights. The creation of specialized courts for the enforcement of intellectual property rights. To moderate this session is Ms. Hibantu Nasser Shobambi. Hibantu Nasser Shobambi, I'd seen her earlier on, beautiful. Let me spotlight her. Thank you very much. Over to you, ma'am.
Hi, welcome everyone. Welcome, thank you for joining the fourth panel session on the creation of specialized courts for the enforcement of intellectual property rights. As Damilola has already said, I will be moderating this session, and my name is Hibatu Nasser Shobambi. I am a lawyer, intellectual property lawyer, and podcast host of the foremost intellectual property podcast in Nigeria, called Everything IP Law. It's a pleasure to be here, and it is also a pleasure to introduce our distinguished panelists, starting with Mr. Obafemi Agaba. Please, Dami, can you confirm if he's on already?
He's not on the call yet, but he'll be joining us in a few minutes.
Okay, and then we have Mr. Folari Aluko. Mr. Folari is a partner at Truman Rockwood Solicitors, and he specializes in intellectual property law, telecommunications law, and corporate commercial transactions. He is the chairman of the board of trustees of the Intellectual Property Lawyers Association, IPLAN, and the executive director of the Intellectual Property Institute of Nigeria. He's also the erstwhile chairman of the Nigerian Bar Association, Abuja branch. Thank you for joining us.
Thank you very much for having me on this very interesting conversation. And good to see you, Hibatu. Thank you to IP Business Capital for putting this together. So over to you.
Okay, thank you. While we are still waiting for Mr. Agaba, I will proceed to drill Mr. Aluko and just create a discourse. Again, the purpose of this session is to sort of discuss the need or otherwise for the creation of specialized courts for the enforcement of intellectual property rights in Nigeria. And this conversation that we're about to have has been, an ongoing global discourse amongst IP practitioners, policy experts. These conversations have sort of raised concerns regarding the benefits, so to say, of establishing specialized IP courts. Some of these concerns will be brought to the fore during our discourse today. So over to you, Mr. Aluko. First, I'd like to know what your position is on this. Do you think Nigeria is actually in need of a specialized IP court? And if so, what benefits do we as a nation stand to gain from the establishment of a specialized intellectual property court?
Okay, fantastic way to start this conversation. Although if we were in a debate, I would say I would probably be against the motion for specialized IP courts. And my reason is very simple. We already have specialized IP courts. I'm referring to the Federal High Court and, of course, the various tribunals, the Trademarks Tribunal, the Patents and Designs Tribunal, the administrative panel set up by the Patents and Designs Act. But primarily, let's say the Federal High Court and the various tribunals set up by the respective acts, Trademarks Act and the Patents and Designs Act. And I think it's important to recognize the fact that, yes, we all agree that intellectual property is it holds pride of place in terms of the general subject matter when looking at disputes generally. But I think this conversation cannot be had, in isolation. And by isolation, I mean in isolation when talking about the general challenges that we have in relation to our judiciary. In fact, if you track conversations around the need for specialized IP courts globally, you find that the common thread is that there's often always a problem with the judiciary that now leads to a conversation about, how do we then, are there benefits for isolating intellectual property disputes and then having a special system for them? So I would say that to a very large extent, our judicial process, has been bogged down by several issues, delay, and so on and so forth. I would say to a large extent that I was talking to somebody yesterday, and I said, if someone were to ask, out of the myriad of problems responsible for delays generally in our courts, and particularly with regards to IP issues, what stakeholder would I say, would hold primary responsibility? And my answer to that is lawyers, and I say that because we operate the common law, our system is common law based. And under a common law system, the judge pretty much is an umpire. Yes, the judge is in charge of his or her court, but the judge cannot, there are limits to the extent of intervention that the judge can make with regards to an issue before the court. So for example, the judge can only intervene to the extent of the claims made by either party. And so in that sense, the judge is hamstrung, or the judge is tied when it comes to subject matter disputes. And to some degree, the extent of determining the speed of the case, to some degree. Now, when you look at, of course, the parties are represented by counsel. I think lawyers really have, if I were to pinpoint one particular category, and I'll explain why I say this. There's this myth of the quote unquote litigation lawyer. Growing up as a younger lawyer, people would say, if you did IP, people would say, oh, that means you probably do IP registration, the trademark registration, and so on and so forth, renewals and so on. And there was this idea that, there are some lawyers who would do quote unquote CAC, which is corporate commercial practice. And then there were lawyers who were litigation lawyers, but it's a fallacy because there's no such thing as a litigation lawyer. You have litigation in intellectual property in the same way you have litigation, in corporate law, the same way you have litigation in election petitions. In almost every area of practice has its administrative components, has its compliance components, and has litigation components as well. And so what then tends to happen, I was listening, it was interesting, listening to the conversation about IP insurance and how I think it was Rita Anwara who said our colleagues, should take the time to ask for help and ask for advice from, subject matter experts. There was a matter that I was invited to handle about 6 or 7 years ago. This matter had actually gone to the chambers of a senior advocate of Nigeria, very popular senior advocate of Nigeria. It was an IP matter, but guess what it was? It was, they hadn't filed, but they were preparing to file. They had prepared their processes, and were filing a fundamental rights enforcement matter. It was framed as fundamental human rights enforcement, and I said no, and then we had to go into all of that. So the problem is that you have lawyers who, because they have an understanding of the workings of procedural law, what they do is, so if that lawyer finds himself or herself, as a defendant or as counsel to a defendant, they use procedural law to delay the case. And so you find cases, going as far as the Supreme Court on an interlocutory appeal before even entering the main suit. So most times you find that if the lawyers really if the lawyers have a very good grasp of both the procedural law and the substantive law, in which, in this case, IP, there will be a lower incidence of unnecessary adjournments. I find, this is anecdotal, but I did a spot survey of IP cases generally. And in fact, most IP cases suffer a lot of adjournments. Most of the ones I have handled, although you try to keep the adjournments to the barest minimum, that's also important. But a lot of the adjournments are really centered around procedural issues.
Hello, Mr. Luko. I don't know if you can hear me. I lost you there for a few seconds. No, I can't. Maybe you should disconnect the external microphone and see. I can't. No, sorry, I still can't hear you.
Okay.
Okay. Yes, I can hear you now. I can hear you now.
So it's technology. We say we're ready for technology, but then I'm sure if you've noticed, I have 2 devices connected to the call,
Okay.
because technology. So, I was saying that if you look at the instances that or the situations where there is delay in the judicial process, you tend to find that a lot of that delay is caused by lawyers exploiting procedural loopholes. Many of the cases that I have personally handled that have suffered delay have been as a result of procedural issues, and that is primarily because you find lawyers who, they say, oh, somebody says, oh, this person is a litigation lawyer, but that person only understands procedural law, and it does tend to elongate or prolong matters, and I would say that again, because the Federal High Court has they say we shouldn't say it has a limited jurisdiction, but it has an enumerated jurisdiction, with regards to copyright, patents, trademarks, industrial designs, and I would refer us to Section 251. A lot of people read of the Constitution.
That was going to be my next question. Okay.
Yes.
So before delving into, so that we don't overlap 2 different constitutions. So if I heard you correctly, you said you do not agree that we need a specialized IP court, that we already do have one in as the Federal High Court has presently constituted, and that what we should be focusing on is specialization, increasing specialized knowledge in the field of intellectual property, if that is
You put it so
am I
beautifully.
correct?
I said you put it so beautifully. I wish you had made the point.
Okay, before we go on, so some people would disagree. So I would be playing the devil's advocate here. Hopefully, if Mr. Agaba can join, maybe he would have a different opinion. Some people would still say that just like as recently adopted in India, they created sort of like a division of their high courts in terms of taking intellectual property enforcement to the next step, just to a separate court, so to say, for handling intellectual property enforcement matters. Some would argue, see what the National Industrial Court has done, improving employment labor jurisprudence in the country, and we need that for intellectual property cases as well. So, and then before you, I didn't want you to jump the gun so that at least I would have some questions to ask you at the end. So you made reference to the Constitution, and that was going to be my next question, that looking at our mother law, the Constitution, the 1999 Constitution of the Federal Republic of Nigeria as amended, especially in relation to creation of courts generally, do you think that even if we are for, creation of specialized courts, do you think that our Constitution or our constitutional framework allows for the creation of specialized intellectual property court as it is now?
I would say, again, fantastic points. I would say that if I were to respond from a constitutional point of view, let's start from, from a constitutional point of view, let's start from there. Section 251 of the Constitution, as we know, that creates the jurisdiction of the Federal High Court, stipulates that the Federal High Court shall have jurisdiction with regards to certain enumerated subject matter. And I would rush to say that, it says with regards to all federal legislation relating to copyrights, trademarks, and then it goes on and on like that. Now, the first part of that clause reads all federal legislation. So this highlights a point that we rarely ever take into consideration when having these conversations, which is that Nigeria is a federal, we operate a federal system, which means the states are supposed to have some level of autonomy. In the same way that the federal government also has its own area of jurisdiction, and it's important to note that in true federal systems, you have where the states have some level of power. Most of what happens in terms of legislation and activity actually happens at the state level, and that's why I would say that if the Constitution specifically referred to federal legislation in relation to those areas. Of course, when you now look at the exclusive legislative list, it then gives the National Assembly the exclusive legislative competence to make laws regulating copyright, trademarks, patents, industrial designs. But that's not the entire gamut of intellectual property. So in other words, there are other areas of intellectual property law that the states have jurisdiction over, because the states have a residual jurisdiction over any subject matter not contained in the exclusive or the concurrent lists. So bringing that down to the question as to the need for specialized IP courts, I would say the Constitution vests, we have a federal system, and because the Federal High Court already has been charged by the Constitution as the federal body, the next question would be, okay, so who then would have the power to make specialized courts or specialized IP courts? So you would say if it were at the federal level, it would have to be the National Assembly. And of course, if we were at the state level, it would have to be the government of the state. And there's a huge, I think there's a lot to unpack in that space there. But suffice to say that there are several, the main problem that people point to when talking about the need for specialized IP course, as I said, is the first problem is delay. And then of course you have maybe specialized knowledge with regards to the judex, and so on and so forth. But the Federal High Court already answers that. And you mentioned India. India created divisions, within the High Court, which is very similar to what we have at the Federal High Court. We shouldn't forget that the state high courts too also have some jurisdiction with regards to intellectual property matters, certain intellectual property matters. I would also say, and I think we should take note that the fact that when the National Industrial Court, when the National Industrial Court was formed, it addressed they addressed the need for a special intervention with regards to industrial relations and employer-employee labor relations, pretty much. But when you look at, if we take the conversation about intellectual property to the next level, the question is, at what point do we stop? I'm sure at some point, Rita, Anwara, and other people will say, oh, we need a specialized insurance court. And then the debt recovery guys will come and say, oh, we need specialized debt recovery courts. And, you have this de minimis splitting, of the judicial jurisdiction, if you may. So I would say that from a logical point of view, it would be much better to have, we already have that specialized court, and I should, a point skipped if you look at other countries, some other countries have specialized IP courts. You look at Poland, for example, you look at China, for example, I would hasten to say that none of these countries operate a common law system. Poland is civil law based. And if you look at some of the countries that have carved out courts for, to address intellectual property as a subject matter for disputes, I would say that to a very large extent, you find that many of these countries, or some of these countries, let's not say many, a large number of them don't operate the common law system. And it will be very difficult to fit these specialized IP courts into the system that we already operate. Not impossible, because as we all know, when the National Industrial Court was passed, there were issues surrounding the jurisdiction. Where does it end? Can appeals terminate at the Court of Appeal? And so on and so forth. Although that has been laid to rest now, and I think the same thing would apply for IP. But then the problem then goes to, if you take it to the next logical extension, who else will ask for a special intervention? That's a big question. And I should say that if we look at the trend when it comes to intellectual property disputes, there's a trend, there's a definite and a deliberate trend that is shifting towards some alternative dispute resolution. So mediation is a growing area in terms of, when I say growing, it has taken hold in some parts of the world, but here in Nigeria, mediation, many IP disputes in many of the creative spaces are actually resolved by mediation. Informal mediation, if you may, but mediation nonetheless, and I've had the opportunity also to participate in quite a number of informal mediation sessions. You just call a couple of people together and say, oh, this person took this person's song, or this person performed this person's song, or this person took this person's script, and everything is resolved around the table. That seems to be in tandem with our our cultural heritage as Africans. So I would say that our constitutional framework actually allows for the creation of specialized courts. The National Industrial Court is one such example, but I don't think it is a function that should be created or that should be exercised, ad nauseum, because the question is, where do you now draw the line? And that might be problematic. I think that there's a need to increase the number of judges at the Federal High Court, which is something that is a process that is currently ongoing. I know that my Lord, the Chief Judge of the Federal High Court, I think some months ago called for, there were some people shortlisted for 16 positions. Another 9 positions have been advertised for, only recently. And so you have that realization that if there's a need to have a federal system for 36 states, then you need to have more judges to address these very specialized and enumerated issues, that these states will have. But I don't think that at the state level, I do not think that we have really explored all the opportunities for intellectual property legislation, if you may, at the state level. And that's one area that I think a lot of work should be done. And I would also say that there should be, it's one of the things I've been trying to do maybe in the past couple of years, is to see how we can translate some of these informal mediation interventions, into the formal mediation system. And so what you have is people using the mediation process, because IP is a very special type of property, and it's property that has, future value and all of that. And because as a result of that, it's easier for relationships to be maintained. I was involved in a matter about 2 or 3 weeks ago, where somebody actually brought in the military police to, harass somebody else for quote unquote IP theft. And, at some point I called the person, while intervening, I told the person, I said to the officer, one of the officers, that, it would be better if the relationships are saved as a result, after this interaction. And the man first laughed, and said, which relationship? This person stole this person's. And I said, don't worry, by the time we get to the nitty, let's not look at who is right. I just did some quick mediation. And at the end of the day, both parties actually came together. In fact, the person the complainant now, went to meet the person against the respondent, went to his office, and they were able to rekindle their friendship. So the point is, our constitutional framework allows for it, but do we adopt it just because there are delays in the judicial process? I would say it's not only intellectual property cases that suffer those delays, and as such, we shouldn't isolate IP. I would love it. It will make my work easier, hopefully, but it will create a huge problem for other areas and for the judiciary in terms of a splintered court system.
Yes, thank you very much, Mr. Aluko, for that detailed response. And but in summary, you went on, you delved into a lot of details, and you said something that was really interesting that I think we need to explore. I'm going to go there. I'm going to touch upon it a little bit. You referred to state level legislative reforms that we need to apply to ensure proper intellectual property enforcement. But before then, I would like to speak to your conclusion as to whether our constitutional framework as it is presently allows for specialized courts. In my mind, and I stand to be different, and again, I'm going to play devil's advocate so that we can explore conversations and arguments that would perhaps even arise in terms of jurisdictions of these specialized courts. Because how then do we juxtapose? Because if you're referring to the National Industrial Court, know that it was or the basis of the creation of that of the act which established the court is from section 6 of the section 6 sub 4 of the Constitution, if I'm not mistaken, that allows the National Assembly to confers the powers to the National Assembly to create courts that will be in subordinate or coordinate jurisdictions with the High Court. And then we have again section 251, which explicitly states that the federal High Court will have exclusive jurisdiction in matters of intellectual property. Although it doesn't, explicitly provide for other forms of intellectual property, but I think it's arguable that we can argue that the intent of the draftman or the intent of the Constitution was to include various forms of intellectual property. And on that note, if a law, for example, the the Intellectual Property Specialized Court Act is born out of Section 6, it will only be at a subordinate or coordinate jurisdiction as the High Court. And then we also have a lot of like a plethora of cases that already states that you know, when there is conflict, especially in terms of jurisdiction, substantive matter jurisdiction with the High Court and the Federal High Court, we would have to refer to Section 251, which explicitly states, you know, that intellectual property matters are strictly restricted to the to the exclusion of all other courts in favor of the Federal High Court. So just trying to juxtapose that, in my opinion, I would say that I don't think a specialized IP court will stand. And the reason why the NIC, the National Industrial Court, on the other hand, will stand is that it doesn't fall, labor matters do not fall under that Section 251. And that's my opinion. I would love to hear from the audience as well if they have contrary viewpoints, opinions as well. So that would be my... Hello?
May I quickly respond to that?
Okay.
Yeah, so interestingly, Gilbert, so what I actually meant was that, you know, if you look at sections 4, 5, and 6 of the Constitution, Section 4 empowers the legislature of the state and of the federation to create laws for the good governance of, you know, either the federation or the state. Section 6 relates to the creation of the judiciary and empowers the federal legislature to create courts for the federal government, or for the federation rather, and states for the state houses of assembly to create courts for the states. Now, if you look at the labor, actually falls within the purview of the National Assembly, labor-related issues is contained under the exclusive legislative list, you know, which is in the schedule to the Constitution. On the flip side, it will interest you to know that, you know, intellectual property is not mentioned in the Constitution at all. The phrase intellectual property is not used in the Constitution. As a matter of fact, if you look at Section 251F, paragraph F of that, you know, the paragraph giving the Federal High Court exclusive jurisdiction, it actually talks about any federal legislation. You know, and one of the things I learned from my you know, rules of drafting is that when you mention the exclusive mention of one thing implies the exclusion of every other thing. So when you talk about federal legislation relating to copyright, trademarks, patents, and designs, it implies that, oh, so there may be state legislation. Does that make sense? And if you look at, I'll give you an example. In the US, for example, they operate both of course, I use the US because we operate a federation system, or a system of federal government is loosely based on the US system. You have state copyrights in the same way that you have federal copyrights. But one of the distinguishing factors is if you want to enjoy the benefits of federal copyright, which is the ability to file an action and to claim copyright infringement, you have to register that copyright with the copyright regulatory body. You know, the only difference is that in Nigeria, when you look at the exclusive legislative list, it excludes legislating on copyrights, trademarks, patents, and designs. It gives that exclusive power to the National Assembly. So this means that it is only the National Assembly that can create laws regulating copyright, trademarks, patents, industrial designs. It also lists a couple of merchandise, trade names, you know, and a couple of other issues within the gamut of, you know, industrial trade and that sector. But the important thing to note is that by applying that, you know, the exclusio unius rule, it implies that other forms of intellectual property, in my own opinion, in my very humble opinion, other forms of intellectual property are within the residual province of the states. So the states, for example, I mean, we don't have, there's no such thing as trade secrets in the Constitution, you know, in either the exclusive or the concurrent lists. So it falls within the residual, I mean, from our constitutional law. So anything that is not contained in the exclusive or legislative or concurrent lists in the second, I think, the second schedule to the Constitution, automatically fall within the purview of the states. And so the states then have to, I have people talking. The states then have to pass laws that address those issues. And I would argue that things like geographical indications, for example, in my very humble opinion, I know there are people who don't agree with me, but you don't find GIs in the exclusive or concurrent lists. And it does make sense for states to have the power to create laws regulating GIs, because it's the state that knows the areas within their locality, that have special value or any special function to them. So the state. Why should somebody in Abuja, for example, tell the people of Ikire how to use Ikire, or Ikogosi, how to use Gosi? You understand? It's better the people in Ekiti or in Ondo, or in Osun State are best positioned to determine how they want to use, or in Ogun State, Olumoro. They're best, they should be the ones who determine how they use their geographical indications. So that's my take when you look at our federal system of, yes. But with regards to the courts, the federal, because the National Assembly, federal legislature has the power to create laws regulating trademarks, patents, copyright, industrial designs. What it means is that those bodies can also create specialized courts to deal with subject matter arising from disputes in that area. But what will now have to happen is, as part of so it wouldn't just be, just as you mentioned, these are issues that have a constitutional flavor. Section 251 sub F already gives the Federal High Court, or delays its power to the Federal High Court. So the National Assembly will have two jobs to do if they want to create a specialized court. But that's why I said it wouldn't be as easy, as with the National Industrial Court, but it's possible. The first job would be, they would have to amend the Constitution to delete Section 251 sub F. They would also have to amend the Federal High Court Act to delete the comparative section in the Federal High Court Act that gives the Federal High Court that jurisdiction. And then they would now create a special intellectual property court that will now, so you'd have to perform some sort of surgery on the Federal High Court and on the Federal High Court Act and on the Constitution as well, in order to create your specialized IP court. Yes, but I don't think it would be as advisable, just as, because again, debt recovery people will wake up and say, you know what, we also want a specialized court, and insurance, and then asset management, and then, and it becomes a town hall, different from, you can fill in the rest, but you get the point that I'm trying to make. I think, just for clarity, for the sake of clarity, that it is possible. The fact that I said it's possible, but that doesn't mean it to be easy. There's a lot that will have to go into it. And I don't think we have the trademarks registry, the trademarks tribunal, rather, the patents tribunal, the Patents and Designs Act also sets up tribunals for the patents registry and the designs registry. The Copyrights Act also creates some dispute resolution mechanism for resolving copyright disputes. So my question is, if we have all these administrative solutions, and administrative solutions are supposed to be a first line intervention before litigation, why is it that why aren't we exploring these administrative solutions? And if we're exploring them, and I'm not saying there are delays, but if there are, how do we fix those delays first before we look at, the issue down the road of creating new courts that may now also, if we're not careful, suffer the same delays that our existing structure already suffers.
Very well said, Mr. Lugo. Thank you very much. I do agree. I think we might have to agree to disagree just on a little part. And I think it's always fun as, I mean, you can't have one or two lawyers on the same page. I mean, there's always a consenting or, dissenting view, right? So just to point out a little thing, a little aspect when you said that by application of the exclusion rule, it would mean that, and again, playing the devil's advocate, I would love people to contribute as well. I would, argue that, or perhaps say that the intendment of the law is to apply, is to refer to other forms of intellectual property as well. And because, I mean, it did mention at least 3 of the significant IP rights that were that were enforced at that time, right? So yes, and when you mentioned GI, geographical indications, I thought it was worthy to know that Mr. Luko, one of our rarest IP heroes in our time, as I would like to address him, he actually fought for or instituted a case, I believe at the magistrate court. I don't know if we heard about the Bata dance and then trying to create a linkage in terms of protection of intellectual property of our traditional heritage and culture. He tried to make a judicial pronouncement, institute a case that, or an action at the magistrate court, if I'm not mistaken, to
customary courts. Sorry,
customary court. Thank you very much. To make a pronouncement on ownership of the Yoruba people's ownership of Bata dance. So that was quite interesting. Thank you very much, Mr. Luko. And again, I think we should go back to, you mentioned, I said we're going to come back to this, so now we're here. Other state reforms that you think that we can explore besides, we can explore before the enforcement of intellectual property rights, besides creation of the specialized courts. Can you speak on that a little bit?
Oh, yes, and thank you very much. Fantastic question. Thank you for your kind words. We actually won the court gave judgment in favor of our claim. That's the customary court. And I remember when we filed that suit, people called and said, oh, this is an IP issue, it's traditional knowledge, it must be Federal High Court, And I said, no, again, we need to understand that there are some aspects of intellectual property that fall within the jurisdiction of other courts, and my answer was, I asked the question, I said, let's say somebody who, a Benin man who lived all his life in Edo State, and owns intellectual property, dies intestate. His intellectual is his, whatever it is, let's say he was a renowned artist, and had drawn paintings and all that. His work would evolve under the customary law of, Edo State, of the Benin, for example. And that would be a customary law issue, assuming there was a dispute as to who owns what. So, and that was the argument. And the first thing that the court did, because there was a counter argument to some degree, and the court looked at this jurisdiction to find out, do we have jurisdiction over this subject matter? And the court actually held that they had jurisdiction. And you'd be surprised. It's interesting that outside the country, everybody knows this. If you go, some of the people who gave evidence came all the way from Ibadan, and they had represented Nigeria at different levels across the world, outside Nigeria at, salsa events. And they said every time people say, oh, Nigeria is the homeland, the motherland of salsa, Bata. And why is it Bata? There's a historical antecedent. There are so many things. And it has to do with the number of slaves who were taken from Africa, to the plantations. Out of all the slaves that were taken, apparently the Yorubas were the largest homogeneous group. The largest group of slaves were actually the Bantu, but the problem with the Bantu at the time was not the problem, but the thing with the Bantu was that the Bantu actually spoke several dialects. So they didn't have one language. But among all the slaves that were taken to the plantation, the Yorubas were the largest homogeneous group. And if you look at Nigeria today, the Yorubas are actually, I think 13% were the largest, and Yoruba as well, were the largest homogeneous group. We speak the same language, that's homogeneous, or very similar dialects. And so it was easy for that culture to translate when they got to their destination, because it's that axis. And so they went with their religion, their gods. That's why you have Shango, you have Yemoja, you have those cultural and historical characters who were translated along with the dance, and all of that. So that's just a little bit of that. Someone said I'm a traditional lawyer. I said no, I'm not a traditional lawyer. But speaking to state interventions, I mean, this is one of them. I mean, I understand your intervention regarding, the use of, is it what figure of speech is it, where the whole is used, one thing is used as a representation of all. I'm not sure that we can apply that with regards to constitutional interpretation. I think one of the rules is that when the Constitution is interpreted, it is often interpreted, especially these sections giving powers, is interpreted as narrowly and as strictly as possible. But where there are provisions that give rights, yes, Sinedoki, thank you. Sinedoki and metonymy, thank you, Shagu. So where there are provisions that give rights are actually interpreted as widely as possible. And so you have, for example, in India, where the right to electricity has been declared to be a fundamental right, which is a component of the right to life. The court will expansively interpret any provision of the Constitution that gives rights. But where a provision of the Constitution gives a responsibility or a power, that provision is narrowly interpreted. And so if we were to apply that, I would say things like geographical indications fall within the purview of the states. And I would say, for example, quick one, I was interested, some years ago to find out what happened. If you look at the US, for example, the US movie industry did not start from, it didn't start from California. It didn't start from California. But movie makers actually had to move to California. One of the reasons was because a gentleman by the name of Thomas Edison had filed patents. He owned patents for a lot of the inventions, that a lot of the technology that went into the use of cameras. And so movie makers had to pay a licensing fee to him to use those cameras to shoot movies. And so a lot of them moved. I don't remember this. I think it wasn't Nevada now, but they actually moved far away from Mr. Thomas Edison. They tried to move as far away as possible. And what you had was a state that provided the infrastructure and the platform for that kind of culture to grow, for a movie making culture. And if you look at a state like Georgia, for example, Georgia gives tax exemptions to certain types of corporations like Disney. In fact, they even created a law, and if you look at, at the end of many series, you see the state of Georgia, the Georgia Apple. The state of Georgia plays a very active role in encouraging businesses. Now, you may not be giving them naira and kobo or dollars and cents, but by ensuring that the state has policies that allow these businesses to thrive. So, for example, you can decide to give land, since that's a problematic issue, but it's one major challenge that I think that's set now, is a major challenge in the movie industry, for example, and even in almost every industry. You could decide to give them that. There are many interventions that states can decide to give, people in the creative space that would trigger or at least invite. Yes, if you look at, so there are two metrics I like to look at when analyzing innovation in any environment. I ask myself, number one, what industry drives innovation? And number two, what state drives innovation? That's states as in municipality. Now, and I'll make reference to the US, it's different in different countries. In the US, for example, the gaming industry drove innovation. It was the gaming industry that led to the innovation, the transition from color TV to Ultra HD that we have, to the need for high-level processors that could handle, the kind of graphics, and virtual reality and all of that. That is the gaming industry drove from I think from the late 70s. The gaming industry has driven innovation in the US. In Nigeria, it's the banking industry that drives innovation. That's why when we had, we're still in the throes of a hiccup, this Naira scarcity, and we can see the extent to which the banking industry has been affected. I don't know how many people use Zenith Bank, in on this call, but you have situations where our technology is the technology in the area of our society that drives innovation, is being challenged seriously. So because our banking sector drives innovation, we find that it is what happens in the bank. Things happen first in the banking sector before they now spill over into other areas of our economy in terms of innovation. So security innovation, content innovation actually was driven largely by banks. The quality of the advertisements, the quality of the content creation and all that. I would say that when you look at states, with regards to states that drive innovation, I think Lagos State, Lagos State is primus inter pares in that regard. And one of the implications was that anyone who wanted to make it in the creative industry would have to physically be in Lagos. And one of the reasons was actually because the distributors, in the era of distribution, the distributors in Alaba, of course, Alaba is in Lagos, were based in Lagos. And so if you needed to, the only way you could reach the entire country was to go to Lagos. And then from there, you could reach the country. But distribution, that has changed. Tech has disrupted distribution, or traditional distribution, if you may, and it has changed. And so, in my opinion, I think maybe for a very short window, there's an opportunity for other states to do things to also take advantage of that disruption. When you look at talent, the talent pool, I would say Lagos maybe ranks a distant fifth or so in terms of the talent pool in the country. If you're looking at where talent is, where you have aggregation of talent, you look at places like Plateau, Jos, you look at Benue, the Middle Belt, you look at Rivers, the South. You don't really look to Lagos, and Lagosians, real Lagosians. A lot of the people who actually do so well in Lagos come from outside Lagos, to find not necessarily to find their expression, but because Lagos State has a system, whether it was deliberately built or it happened by chance, but Lagos State has a system that allows innovation to thrive. So for example, every weekend on every street, in almost every part of Lagos, there is a party going on. And of course, in order to make parties move, you need music, and then you need this, you need that, all centered around entertainment. So I would say that these are things that states need to look at. How do we create this enabling environment? And yeah, it's a longer conversation, but we have a limited.
It really is, and we've been asked to round up, but I just didn't want to interject because interesting stuff you really explained, and you even delved into my next set of questions in relation to what are the next steps, how can we move on from here to ensure effective enforcement and protection of intellectual property rights for creatives and innovators. So thank you. At this point, you need to be on perhaps a state policy dialogue or panel so that we can share some of your insights. Thank you so much. Again, I think you have delved into a lot of, what I even really find interesting about intellectual property is that it cuts across a diverse range of sectors. We're talking about policy, we're talking about tax regimes, we're talking about financial sector, and every sector that you can think about. Thank you so much. It's been a pleasure having you join us for this discussion. I learned a lot, and I'm sure the listeners also did. I hope I've been a wonderful moderator. My name is Hibat Nasir Shomanbi. For those joining in, thank you so much.
Thank you, Hibat. You've been a fantastic moderator. And as my people in Ekiti State, it has been my pleasure. So,
thank you very much. Bye, everyone.
Thank you so much, Hibatu Nasir, and of course, Mr. Folarin Alukosa. You owe me a phone call after this convention. But thank you so much to every single person for listening and, of course, contributing so far. That definitely was a very rich discourse, and I am delighted that we had Mr. Folarin Aluko to share with us on whether or not there is a need for specialized courts when it comes to intellectual property in Nigeria. Moving on, oh well, before we move on, let me take a minute to get feedback from us in the comment section. I see already that Oluwasegun Idowu has said it was a really rich conversation. Thank you very much, Oluwasegun, for your feedback. I'd love for other people as well, in one word, 2 words, a sentence, share with us your feedback on the just concluded session, talking about the needs, if any, for specialized IP courts in Nigeria. While I await your feedback, I have the honor of introducing our first keynote speaker for the IP Annual Discourse, Ms. Beverly Agbakoba Onyejianya. She is a career mom of 3. She's a public speaker, a teacher, policy development writer, and of course, a legal and compliance professional. She heads a team of specialist lawyers who provide legal compliance and regulatory advisory services to individuals, startups, organizations, and companies. Ms. Agbakoba is recognized as a thought leader in the area of sports law and is listed with the Who's Who Legal as a sports law expert. She's also a member of the MEPAD class of 2022, Law and Justice, the most influential person of African descent. Earlier on, of course, I'd shared with you some of the books that she and her team at OL have come up with, the A to Z of sports law in Nigeria, Set's Guide to Entertainment Law, amongst many others. Ms. Agbakoba is a seasoned policy and regulations developer and has been part of several committees and working groups tasked to develop various policies, from the development of the updated National Sports Policy for Nigeria, National Policy for the Creative Sector in Nigeria, and also for the development of the geographical indications for Nigeria, to name a few. She is regularly invited to speak at international and national conferences on sports, governance, intellectual property, we have her here, of course, regulatory compliance, and of course, personal development. Interesting to note is that Ms. Agbakoba Onyejianya actually speaks fluently in both English and French. Ladies and gentlemen, please join me, welcome and give a warm round of applause to our keynote speaker, Ms. Beverly Onyejianya, who I must say has done the impossible to ensure that she's a part of the discourse today. I've been a part of the back and forth. She just got off a flight, but she is here with us. Thank you so much, ma'am. We deeply honor your presence and we're grateful to have you.
Thank you so much. I'm so delighted to be here against all odds, delayed flights and traffic. I said nothing is going to hold me back, no mountain high enough. It's such an honor to be here at this august occasion talking about intellectual property. And again, thank you so much to the organizers for having me to share my keynote speech with you all. So good afternoon, ladies and gentlemen, my senior members of the bar, my learned colleagues. It is really a pleasure to address you this afternoon, and I hope I will do it justice. I really enjoyed the previous discussion that just took place. And I actually wanted to say something really quickly to that point about Lagos being the driver for innovation of all kinds, not just IP. Did you know that over 26,000 parties happen every weekend in Lagos? It's unbelievable. I got this fact. Yes, 26,000. I was a judge at an event recently, and it was all about the creative economy. And yeah, I don't want to go too much into it, but yes, 26,000 parties take place. So you can really see that that activity, you know, created by the small, medium-sized economies, by people like me and you, that is what is the real driver for economies. Not necessarily, not the big companies at the top. It's me and you and our neighbors and our communities that are driving change. So without further ado, I would like to get into my paper. I prepared a paper for this. Okay, so I'm going to start now. Thank you once again for having me today. I'm so honored. I'm so delighted to be talking to you about the critical role that IP plays in small and medium-sized enterprises development, economic growth, and investment promotion in Africa. SMEs, as we all know, are regarded as the engine of economic growth and development in most developing countries. The contribution of SMEs in the industrial sector of Nigeria is currently valued at about 46%, just under half. This means it is the second largest contributor to the nation's GDP after oil and gas. So, you know, the SME sector is not a sector to play with at all. It has the power to transform the economy. Why? Because of the sheer volume of participants that are playing in this sector. And not only that, it has the potential to build an even stronger foundation for the growth of new industries. I believe we've heard a lot about AI this year. We've heard a lot about the likes of ChatGPT and how it's going to change the way we work, the way we live, etc. So SMEs are the backbone of society, and this is all over the world. It's not just in Nigeria. SMEs are the number one source of jobs. It provides job creation, it provides security, and it changes lives. It helps improve the standard of living for people. In today's rapidly evolving business landscape, we've seen how IP has become an essential tool for entrepreneurship. And businesses of all sizes can participate by virtue of the SME sector, especially in Africa, where we've seen particularly women contribute and play their part to building the backbone of the economy. I would also like to highlight the importance of SMEs in Africa as a whole. We are a young continent. We are the youngest continent on the planet, which means we have the potential to truly make serious changes by virtue of our participation in this sector. In fact, 90% of most businesses are SMEs. So when you think about the blue caps, the blue chip companies, you think about the public quoted companies, those are a smaller percentage. We hear more about them because they get more media coverage. But the truth of the matter is, in our daily lives, let's be honest, we are interacting with an SME in one form or the other, whether you're buying ice cream for your kids, whether you're ordering small chops for your birthday, whether you're ordering Valentine's is coming, you're ordering some flowers from a lovely florist. Look, SMEs play a role in our daily lives. And it's only going to get more. It's only going to increase. Now, how can IP be a catalyst for SME development in Nigeria? Through the protection of ideas, inventions, and brands, by patenting, trademarking, and copywriting, SMEs can secure their competitive advantage in the market. This not only helps them attract investment, but also enhances their credibility and reputation. So we're trying to encourage SMEs to move away from the days where things are manual, there's no name, there's no brand, it's just, you know, some nice lady you know in the neighborhood that's selling the best puff puff you've ever tasted. We want SMEs to move further into the future, to begin to establish their brands. Don't forget, big things started small. Also, SMEs can also license their products, their services, generate additional revenue streams. just generally increasing their overall competitiveness. And we can see how that has a direct impact on economic growth in our country. SMEs protect their innovations, ideas. When they do these things, they're more likely to invest in research and development. But the truth is, the sad thing is currently, according to a report by Vera Songwe, Africa invests the least in research and development globally. And that is why we registered the least number of patents. When you think about continents, countries like China that register up to 9,000 patents a year. And then in Africa, we're talking less than, say, 500 for the whole continent. So you can see that there's a huge gap. And that gap is caused by ignorance. It's not to say that we are any less bright or any less capable. No, it is truly for lack of having the information at their fingertips. So when we invest more in R&D, when SMEs know the benefits of investing in R&D, that again will fuel economic growth by creating more jobs, increasing competitiveness and increasing innovation, and making our continent more attractive, a more attractive destination for investment. In addition to fostering SME development, economic growth, IP is also an important tool for investment promotion. By creating a stable and predictable business environment, IP protection encourages foreign investment. We know this is true. We know this. As investors are more likely to invest in a market that provides adequate protection. You see, one thing that potentially has stopped the West from coming in more into our market as far as the creative industry is concerned is not because they think, we don't have the creative wherewithal, but really it's because can they guarantee that there will be adequate protection when things go wrong, when disputes arise? Again, my colleague in the previous conversation talked about the need for specialized IP courts. We've already seen the success of specialized IP courts in places like, again, China. China seems to be leading the way in terms of innovation as far as IP dispute resolution goes. We need to see more specialized courts, which can guarantee speedier and more balanced decisions. We don't want to spend, SMEs, the last thing they want is to have their matters decided by justices that don't know much about IP. Okay, or to see their matters drag on and on for years, potentially taking away revenue, killing off a department, killing off their creativity, making them feel like, what is the point? So truly, there is a need for more specialism in order to protect the SMEs, okay? And that, again, we keep reiterating this, it will increase economic activity, job creation. A successful IP system is crucial to the growth of small and medium enterprises in Nigeria. We know this. They need better support, they need better protection, they need more tax relief, so many things. The list goes on and on. We have so much to lose when our SMEs do not get the protection they need. Already, we've seen what happened during COVID. So many businesses did not recover for various reasons. No, there was no financial support. Let's not talk about that. There was no financial support. Companies that were hard done by couldn't bounce back. So SMEs truly need that support because they add so much value to the economy. IP is a consideration in everyday business decision-making. Moreover, the acquisition of IP property rights, how do we encourage our SMEs to protect their IP rights? What is the role of all of us gathered today as lawyers, as legal practitioners in our various areas? We all have a collective role to play. Kudos to the conveners of this fantastic discourse. It really tells us that there is a need for us to begin to address this more. These conversations need to be happening more often, and perhaps we need to we need to put IP more at the forefront of a lot of our conversations. How truly can the legal industry be a catalyst for that change? What are we in our various practices and firms doing to help secure the protection that these SMEs need? So SMEs truly are at the forefront of a lot of investment opportunities, but can they access those opportunities if they are not fully prepared? So again, we're talking about investor readiness. Right now, there's a surge in interest in Africa, but they are going more so towards the tech companies. What about all those non-tech SMEs that are doing very well, adding value to the economy? Those in the confectionery industry, those in the food business. I can also tell you, I got some data the other day, and apparently the fast food business contributes about 1.3 trillion. Trillion. They make so much, and this is a combination of the registered businesses and unregistered. So we really need to look a bit differently at these SMEs. How can we support them? How can we reach them better? A report from PwC called The Impact of Intellectual Property Infringement on businesses and the Nigerian economy showed that just a 1% improvement in trademark and copyright protection can increase our foreign investment by 3.8%. So for that lovely lady selling, rice from her house but hasn't given her company a name, or that person who's doing puff puff, or the person doing roses, we need to encourage these people to step out of the shadows, to register these businesses, to run their businesses properly, to structure their businesses. We need to be the advocates and the gatekeepers for change. That's the truth. We all want change, but that change can only come if we begin to reach out more to these SMEs, to tell them the benefits that they can enjoy simply by running a more structured business, and also by taking a greater interest in IP protection. A lot of them don't really understand it. We all know here, but do they know? So the truth of the matter is, IP protection, we know it's a catalyst for SME development, economic growth, and investment promotion. But the SMEs themselves don't know this. So we need to bridge that gap. We all need to take it upon ourselves to spread the gospel of the benefits of IP, what it can do, how it can change lives. We've seen very small businesses start as mustard seeds and turn into massive acorns, in just a few years. There's so many well-known brands we know and enjoy today, from the likes of Tantalizers and Sweet Sensations, etc. These all started out as very small businesses, and now they enjoy the complexities of franchising and you name it. So truly, SMEs have a massive role to play. And we need to play our part as lawyers. Each and every one of us here is charged to go out and continue to be advocates for SMEs in particular. So on that note, I leave you pondering on how you can do more after today, after this fantastic IP discourse. How are you going to take the bull by the horn and do more to encourage your clients to talk to more people, to have outreach programs, to join hands? It's a collaborative effort. And once again, I want to thank the organizers for having me. I apologize profusely for having the time changed over and over again, but I thank you so much for this opportunity, and I wish you the best deliberations. I know most of the day is well spent, but I certainly wish you a fantastic masterclass for tomorrow. Thank you so much.
Thank you so much, ma'am. Thank you very kindly. Can we please give her a round of applause, Thank you so much for making the impossible possible and ensuring that you have come to share with us at the IP Annual Discourse. Thank you so much, ma'am, for sharing your thoughts with us. Amazing contributions you have made, especially speaking to our theme, intellectual property as a catalyst for SME growth economic development, and investment promotion. Can we all just say our thank yous and appreciate her in the comment section? I really want to see us do that as we appreciate our keynote speaker, our first keynote speaker, Ms. Beverly Oyejanya. Thank you very kindly, ma'am. Thank you so much, ma'am. We're so delighted to have had you share with us. The statistics that you came with was something that definitely blew me away. The number of food businesses in Nigeria, the amounts generated, trillions of naira. Definitely, we must keep our eyes on that sector. And of course, parties. Oh, I'm there as it is in Lagos every weekend. That was a lot. I knew it was a lot, but I did not expect it to be that many number of parties every weekend in Lagos State, Nigeria. Thank you for sharing very brilliantly with us, ma'am. We truly, truly appreciate you. The conference is moving on. We're moving on to our next topical presentation. And this topical presentation is going to address the ARIPO trademark system. To make this presentation, we have Mr. Jabulani Kwaramba. Mr. Jabulani Kwaramba is an associate at Honey and Blackburn, one of the most prominent law firms in Zimbabwe. He is a highly skilled lawyer in intellectual property litigation, prosecution of patents, trademarks, plants breeders' rights, and industrial designs. He currently serves as the administrative officer for the Zimbabwe Institute of Patents, and he's also a trademark agent. He regularly advises corporate organizations on IP protection, and he has a vast knowledge on protecting intellectual property creations at ARIPO. Mr. Jabulani Kwaramba has appeared in the High Court of Zimbabwe, representing large portfolio of clients on issues relating to intellectual property. While he's not immersed in law-related activities, you'll find him playing, composing, or performing live music. Ladies and gentlemen, please put your hands together and give a warm welcome to Mr. Jabulani Kwaramba as he comes to talk to us on the ARIPO trademark system. You're very welcome, sir.
Thank you so much for that, Damilola. And thank you for the brilliant job that you've been doing sharing this conference. I've been attending the whole day and you've been doing a phenomenal job. And I'd also like to say thank you to the conveners and the organizers of the IP Annual Discourse, IP Business Capital. You guys are doing a phenomenal job. I think we do need more platforms like this where we get to discuss and ventilate these IP issues that are critical to the success of businesses and in particular SMEs. And thank you to Ms. Beverly. That was a very insightful presentation. And I love how you spoke about how SMEs are the catalyst for revenue production on our continent, in our countries, as well as the interface that we do have with SMEs on a daily basis. I think oftentimes we take it for granted just how much our SMEs are contributing to the GDPs of our nations. So I'm going to start with a presentation on the ARIPO trademark system. If I can just be allowed to share my screen, if that's okay.
Okay, Laura, can you kindly make Mr. Kwaramba a co-host so that he can share the screen? Okay, go ahead, sir.
All right. Can everyone see my screen now?
Yes, sir.
Sure, so I'll start us off. My name is Jabulani Kwaramba. As Damilola mentioned, I'm an IP attorney at Honey and Blankenberg. We're a full-service law firm based in Harare, Zimbabwe. So apart from intellectual property matters, we do handle general business law, commercial law, estates, and wills, and a whole variety of legal matters that we assist our clients in. So I mean, the first question would be, what is a repo? A repo is a repo stands for the African Regional Intellectual Property Organization. It's an intergovernmental organization that grants and administers IP titles on behalf of its member states. And the membership of a repo is open to all member states of the AU or the United Nations Economic Commission for Africa. A repo is created by agreement of the contracting states at the time in Lusaka, Zambia on December 9, 1976. And at present, there are 22 states that have acceded to the repo protocols and are able to be designated in either in a repo trademark application and repo patent application, utility model application, and a whole variety of intellectual property rights. So the repo secretariat is based in Harare, Zimbabwe. So a brief outline of my presentation today. As you can see on the screen, we're going to talk about the contracted states, the legal instruments, and we're going to finish off with registration and publication of trademarks in a repo. So as I mentioned previously, there are currently 22 member states in a repo, and of the 22 member states, 13 are contracting states of the Benjou Protocol on trademarks. Now, the Benjou Protocol on trademarks is a legal instrument for administering trademarks in a repo. So I've beamed those states that are party to the Benjou Protocol, and they are on the screen. There are 13, as I mentioned. Suffice to mention at this point that a repo has been making efforts to expand accession by other member states. When I started practicing in 2018, there should have been about 10 member states that could be designated in a repo trademark application. Now, as of 2023, there are 13 states. So the repo secretariat has been making concerted efforts to increase the number of contracting states to their protocols. So as I mentioned before, there are legal instruments that are used to administer trademarks in a repo. There's a Benjou Protocol on marks. Then there are the regulations for implementing the protocol. And then there are administrative instructions also used for implementing the protocol. And in conjunction with these repo legal instruments, at a national level, the national trademark laws of each different state are applicable. And I'll go into that later when I speak about trademark oppositions. The repo Benjou Protocol marks was adopted by the repo Administrative Council at Banjul, in the Gambia in 1993. And the Benjou Protocol is an empowering provision for the registration and administration of registered trademarks on behalf of the contracting states of the Benjou Protocol. So the protocol establishes a trademark application filing system where an applicant can file a single application through the repo or through their national states, and it can designate the different 13 states that I mentioned prior. So that's the advantageous thing about it, is you file one application in a repo, and through that one application, you can designate simultaneously 13 different states. But with that, there's a downside, which is that of the 13 states that can be designated in a repo Benjou Protocol application, only Botswana, Malawi, Namibia, Sao Tome and Principe, Zimbabwe, and Mozambique have domesticated the Benjou Protocol. So what that means is only those states have made their repo protocol part of their national laws in a sense. So that does create some challenges where the enforceability of repo trademarks in states that haven't domesticated the legislation is questionable. But in the ones that I have mentioned, the repo Benjou protocol forms part of the national legislation, pardon me. So registration and enforceability in those states is conclusive. And while all contracting member states are common law countries in which an international agreement can only become part of domestic law when enacted into national law by a legislator, a repo stance is that by having deposited instruments of accession in a repo and having become part of the Benjou Protocol, the contracting countries are bound by the protocol, or the international regional law overrides the national law in the event of lack of harmonization. So what we're saying here is that when a state has made the Aripo-Banjul protocols part of their laws, it is assumed that they are binding on these states, and the protocol is automatically becomes part of the national laws of that state. And one of the advantages that you find in Aripo is that every year they host what's called an annual workshop on the improvement of the protocols relating to industrial property. So Aripo invites member states, agents in member states. It also invites the observer states to sit down over a number of days to discuss the protocols and devise methods and ways of improving the protocols. So over the past couple of years, Aripo has brought us to the table. We discussed certain provisions in the protocols that are somewhat problematic. If there are problems with drafting or agents, member states are not clear on specific issues. Aripo has an open door policy in a sense, where they invite us to lend our voice to the provisions of the protocols and how they can be improved. So it's a very dynamic arrangement where I suppose, like any law, it's not static. And the nice thing about the Aripo protocols is once we discuss improvements to be made with the Secretariat, and the Secretariat is in agreement and they pass a vote, in the very next year, we will see those improvements being brought into the protocol, making administration of the protocol and filing of trademarks and prosecution easier for agents and member states. So I just wanted to give us a brief synopsis of the numbers and figures, just to give us a general overview of the volume of applications that we have in Aripo. So the number of trademark applications filed in 2021 increased by 49% from 342, to 510. So 342 trademarks applications were filed in Aripo in 2020, and in 2021, 510 were filed. So this is a big jump. And I suppose that the decrease in 2020 was attributed to COVID. But in 2021, there was an exponential growth, bringing the number of filings to 510. So if you can look right at the top of our graph here, where my mouse is pointing, in 2017, there were 381 trademark applications filed. In 2018, there were 368. In 2019, there were 408. 2020, due to COVID, there were 342. And in 2021, there were 510 trademark applications filed. So we can see there is an obvious growth trajectory in the number of filings in Aripo. And in addition to the number of trademark applications filed, there's also been an increase in the number of classes. So in 2017, there were 782 classes that applicants filed their applications in. And in 2021, the number of classes increased to 1,050. So a question that can then be asked is, look, my state, my country is not a member of Aripo, and you are quite impressed, or you find the Aripo trademark filing system appealing. In the Banjul protocol, there are provisions for accession to the Aripo protocols. So any state which is a member of Aripo, or any state to which Aripo membership is open, which is any African state or any AU state, like I mentioned before, may become a party to the Banjul protocol by signature, followed by the deposit of an instrument of ratification, and also by depositing instrument of accession in Aripo. So once instruments of accession have been deposited in Aripo, as well as instruments of ratification have been deposited in Aripo, the Aripo Banjul protocol then comes into force 3 months after depositing the instruments of accession in Aripo. meaning that after those 3 months, that particular state can then be designated in an ARIPO trademark application. So I'm just going to delve briefly into the ARIPO Banjul protocol mark cycle. So we start in this section here with the filing. Then from the filing, the next stage is the formalities examination. And then from the formalities examination, which is conducted by ARIPO, we go into substantive examination, which is conducted by the designated states. And after the designated state has conducted substantive examination, ARIPO then publishes the application for registration. And I'll delve into that later as we go on, but I just thought it prudent to give us a brief overview of the cycle of the Banjul marks in ARIPO. So I'll take that again. The first step is filing the trademark. And then the second step is the formalities examination, which is conducted by ARIPO. The third step is the substantive examination, which is conducted at a national level by the designated states. After the designated state has examined an application substantively, ARIPO then publishes the application in the ARIPO journal. And in between this, there are renewals, assignments, appeals, reinstatements, and abandonments that also happen within that ARIPO trademark cycle. So the first issue we'll discuss is filing the actual trademark application. An application can be filed either directly with ARIPO in the ARIPO office or at the office of a contracting state, which serve at the receiving office, and they transmit their application in ARIPO. So the first thing you can do is file the application directly with the ARIPO office, or an agent, a trademark agent, can elect to go to their national office and file the application in the national office. What the national office then does is they take that application and they transmit it to ARIPO, where ARIPO will conduct the formalities examination, as I discussed before. So there are various ways within which an ARIPO trademark application can be filed. It can be filed online, walk-in, by postal, courier, email, or fax. Although fax and postal doesn't happen much these days because we are in a digital world and digital environment now, so there is no need. And walk-ins are also permissible. But as I mentioned, the ARIPO Secretariat is based in Harare, Zimbabwe. So a lot of these methods aren't feasible, like walk-ins. So what ARIPO has done, which is the beauty of it, they have a very efficient online system. So for all the trademark agents and other attorneys on this seminar today, you might appreciate the events that unfolded during COVID. I know certainly for me as a Zimbabwean agent, now as Zimbabwean Intellectual Property Office, we had issues where we were not able to file trademark applications at all because the national office will be closed due to COVID. So it really created a problem where we couldn't file at all. But the beauty of ARIPO was during COVID, their systems are entirely online. So the whole process from filing to registration, any document can be filed in ARIPO online. They have an online platform there. You can create an account and all correspondence, all filings can be done digitally on the online system 24 hours a day. Payments can be made online. Correspondence and official action are sent by ARIPO online when you create a profile on the online platform. So it is very, very convenient and they are very efficient. Correspondence is quick, examination, any questions that agents may have with the registrars in ARIPO, those are swiftly dealt with. So different categories of people can file a trademark application in ARIPO, and this is dealt with in terms of section 2.2 of the ARIPO Banjul Protocol marks. The first category of people we have is a natural person, or a legal person can also file a trademark application in ARIPO, or a representative of the applicant. So these are your agents and your attorneys. And it's important to note that representation is required where the applicant is not a national of any of the contracting states or does not have a place of business within any of the contracting states. So if you want to file a trademark application in a repo and you want to obtain representation either through an attorney, only an attorney from a state that is a member state of a repo can file an application. So I'll give you an example of me. I'm in Zimbabwe, and say, for example, you are in Nigeria and you require a trademark application in the repo. You'd have to engage a trademark agent who has right of appearance in a repo. So representatives in a repo can only be from any of the contracting states. So I'll delve briefly into the filing requirements, which are in terms of Section 3 and Rule 4 of the repo Banjul Protocol or MOX. There are a variety of documents that are required upon application. And as I mentioned before, all this can be done online. You download what's called the repo form M1, which is the application form, and you're required to fill in a myriad of details. So the name and address of the applicant, the designation of the contracting states. So the form has blank spaces where you can fill in name of address of the applicant, and you get to decide which states you want to pick. Of the 13, you can elect to choose 1 or 2 or 3. It really is up to you. You're not obliged to designate all the contracting states. The beauty of it is you can actually get to choose. You can get to decide which state you want to designate based on a variety of factors, possibly your market presence in that particular states. You're thinking of expansion in that particular state. You're not constricted to filing applications in all states. You get to decide, you get to choose based on the strategy that your business is wanting to undertake and where you want to have a presence in. So in addition to all these details, you can attach a representation of the trademark if it is applicable, and insert patent color codes where you'd like to claim color. The NIS classification of goods and services also has to be included, the fee payment. And it's also important to note that if you are an agent, you require a power of attorney if you are filing the application on behalf of someone else. And in addition to these documents, if you are claiming priority from a previously filed application in a convention country, that priority document has to be furnished within 3 months. And I'll pause to say here that you do not have to file physical copies of these documents that I've mentioned. As I mentioned, a repo has an online system, so all these documents can be filed online. For example, your power of attorney, you send it to your client, they sign it, they send you the hard copy, you can scan it, and then file it in a repo as a digital copy. You do not have to send physical copies of documents in a repo, which is the beauty of it, as I mentioned. The second step is the verification and processing of the application at a repo. So there's certain requirements that are specified under Rule 4 of the Banjul Protocol, which I will go into, which are required when the application is being processed on a repo. So once you file the application, a repo verifies the documents for fulfillment of their various filing requirements. And should the applicant be non-compliant for one reason or the other, a repo will send correspondence to the applicant or the agent's applicant requesting them to rectify or remedy that non-compliance. So once an application is filed in a repo will provide a filing date and an application number accompanying each application, provided the application meets the requirements in Rule 4.1. So once the application has been received, a repo will issue what is called an acknowledgement of receipt of the application, containing the filing date of the application. And if you are claiming priority, that priority date. And this notification of receipt is also sent to the applicant and it is copied to all designated states. And a payment receipt is also issued where payment has been made. Now, I suppose I should mention at this point that in addition to payment, a repo does afford applicants a window period of 21 days within which to make payment of their application. So as I mentioned previously, a repo conducts the formal examination of the applications, which I'll go into now. So a repo conducts a formality examination to ensure that the prescribed formal requirements are complied with. So they'll issue a notice of compliance with formality requirements to the various designated states and the applicants. And when there is no compliance, as I mentioned before, a repo issues a notice to the applicant and the various designated states. And once a repo office issues a notice of non-compliance, the applicant is given a period of 2 months within which to remedy that non-compliance. So for example, you file an application and you have not included the power of attorney. A repo provides a period of 2 months from the filing date in a repo within which to provide a power of attorney. So in addition to all the other formality requirements, a repo requires payment of excess words in each class specification. So for words in the specification that go above 50, a repo charges a surcharge for $5, 5 United States dollars for each additional word. And in addition to all the other documents I mentioned, a declaration of actual or intent to use the mark is required in a repo. Priority declaration, as I mentioned, is also required. A translation or transliteration of the mark is also very important when you are filing the application. And also indication of whether or not you're the owner or the registered user. And when an application complies with the repo formality requirements, a Form M8 is issued. And again, this is sent to the applicant or the agent's applicant, and it is also copied to the various designated states. And this Form M8 is also a request by a repo to the designated states to begin conducting the substantive examination. So these are some of the things I mentioned. The non-compliance is issued on Form M4. And on failure to comply within the stipulated period, the application will be refused. So we're moving on to substantive examination. And as I mentioned previously, substantive examination is conducted at a national level. It's conducted by the national states or the states that have been designated in the application. So repo transmit all relevant documentation that has been submitted by the applicant to the designated states. And the designated states have a period of 9 months within which to either accept or reject the mark. So that's 9 months from a repo transmitting all the relevant documentation. The designated states has a period of 9 months within which to accept or reject the mark. And the thing about this is, if the designated state does not communicate to a repo whether they have accepted or rejected the mark within that 9-month window period, a repo moves to automatically accept the mark. So I'll say that again. Designated states have a period of 9 months within which to communicate to a repo and to the applicant whether or not they have accepted or rejected the mark. If they do not communicate with the repo within the 9-month window period, the mark is automatically accepted. And I suppose, again, this is the beauty of it, is that one of the things that we do find at national level is most times our IPOs are under-resourced. So examination of application, processing of application, and reverting to applicants and agents takes a really long time. but a repo has a mandatory 9-month period within which to designated states have a mandatory 9-month period within which to communicate to a repo and the applicant. And if they do not communicate within that 9-month period, the application is automatically accepted, or it is deemed automatically accepted by a repo. And once the application is transmitted to the designated states will issue examination reports. So they examine the mark substantively in their register. They register against marks that are existing on the register, or whether or not the mark is acceptable in terms of the national laws of each state. Because if you recall, I mentioned at the beginning that trademark applications are examined substantively by the national states in accordance with their national laws. So once the application has been examined, the national state or the designated state will issue either a Form M9B, which is a notice of acceptance, or it will issue a Form M9, which is an outright refusal or a notice of conditional acceptance. So if an applicant or representative of an applicant feels like they've been hard done by a refusal by the designated states, they may request the designated states to reconsider their communications. So for example, you file an application in a repo designating one state. It goes through formality examination and the repo accepts it at that stage, and then the application is transmitted to the designated state. If the designated states issue the Form M9 and it requests that the applicant disclaims a word or disclaims a letter or disclaims a particular phrase in the trademark, the designated state will make that communication through Form M9, inviting the applicant to either disclaim a word or to either provide a translation or a transliteration of a trademark. It will do that through Form M9, and the applicant will then make a request for the designated to reconsider their decision through Form M9C, or the applicant can either agree to a disclaimer or provide objections or submissions in response to the decision of the designated states. So that's done through Form M9C by the applicant. And once the applicant responds to a notice by the designated states, the designated state has a period of 2 months from the date of submissions by the applicant or the applicant's representative within which to make a decision. And if the designated state does not revert within that 2-month period, the application is automatically considered accepted again by the designated states. So I'm sure you might notice this trend. There's a trend here. The repo is trying to ensure that applications are dealt with as swiftly and as efficiently as possible. That's why they have these strict deadlines, if it were. So where the designated states does accept a mark, this notification is sent through what is called Form M9B. And when the application is accepted by the designated states, a repo shall, without delay, communicate the decision to the applicant. And once the mark has been accepted by the designated state, or the 9-month period has lapsed, the application will be published for opposition purposes in the repo journal. So the publication in the repo journal will indicate the name of the applicant, the number of designated states, and the niche classification. So what this does, it invites third parties who may possibly want to oppose registration of the mark to file their notice of opposition and objection to registration of the mark. So that's all done within a 3-month window period when the application is published in the repo journal for opposition purposes. So the publication happens for a period of 3 months. inviting third parties to oppose registration of that trademark. And as I mentioned, any person may give a notice of opposition to the registration of a mark at any time after the publication in the Marks Journal of an application as accepted before registration of the mark. So that's that 3-month window period that I'd spoken to previously. Once the trademark is published in the Repo Journal, there's a period of 3 months within which to oppose registration of the mark. If opposition comes after that 3-month period, then a Repo will not accept that opposition. So in the event that an opposition or notice of opposition is filed, or in the event that any person wants to file a notice of opposition, what they do is they file their notice of opposition in a repo, and the repo notifies the designated state. Because when a party decides to file a notice of opposition, what they have to do is to state in which designated countries they wish to oppose registration of the trademark. So say, for example, it's a trademark application designating Zimbabwe and Botswana. A third party may elect to oppose registration of the trademark in Zimbabwe, for example. So what they will do is they will send a notice of opposition to a repo, and then a repo notifies Zimbabwe of the opposition. They may elect to oppose registration of the trademark in both Zimbabwe and Botswana, and that is permissible. So what a repo does is they'll notify both Zimbabwe and Botswana of the notice of opposition. And why this is important is because oppositions are dealt with in terms of the national laws of the designated states. A repo is not empowered to hear notices of opposition or to hear opposition to trademarks. These are dealt with in terms of the national laws of each state. So what happens is the third party that wishes to oppose the mark files the notice of opposition in a repo, and then a repo transmits the notice of opposition to that designated countries, and this is dealt with in terms of the national laws. So once that happens, is that the applicant will have to appoint a representative in that state to handle the opposition. So for example, if I file a trademark application in respect of Botswana, designating Botswana, and I file it in a repo, if we receive a notice of opposition of that trademark in respect of Botswana, as a Zimbabwean attorney, I cannot then deal with the opposition because it's in Botswana. The applicant would have to engage an agent or a trademark attorney in Botswana who has right of appearance before the Botswana IPO to handle that opposition. And the final stage is registration of the trademark. A repo registers a trademark which has been accepted only by the designated states. So after the trademark application has been published in the Repo Journal for opposition purposes, and there is no opposition, the applicant can then apply for sealing of the application, or they can apply for issuance of the registration certificate. So the registration certificate will be endorsed with all the designated states that have accepted the mark. And the registration of the mark is published in the Repo Journal. And for one reason or the other, an applicant decides that they would wish to designate additional states, and either after they have filed the application or whilst the application is being processed in a repo, they can file what's called a subsequent designation of additional states. So what we have seen a lot of this is where a new state accedes to the Repo Benju protocol. So last year, Cape Verde acceded to the Repo Benju protocol. So we had a lot of clients that would then come to us and they would already have a trademark registration in a repo, or they have a pending application. So what they do is come to us and request us to file what's called the subsequent designation of the additional state, so that they can seek additional protection in that territory, which in this case was Cape Verde. So where an applicant elects to designate an additional state, such designation is deemed to be an application in respect of that subsequent designation. And the period of protection under the subsequent designation expires on the same date as the earlier registration. So for example, if the original trademark application or the first trademark application was on the 1st of February in 2020, if an applicant comes on the 1st of February in 2022 and they wish to designate a state that they had not designated upon filing the application, they can do that. So once that subsequent designation is examined and it is accepted, the date of filing or date of registration will be that earlier date, which should have been 1st of February 2020. So that is it for my presentation on the repo trademark filing system. Thank you so much for the opportunity. And as I mentioned before, the repo system is very efficient. Everything can be done online. Everything can be processed online, which is the beauty of it. And there is efficiency. They work with a great deal of speed and haste in processing applications, and everything can be done digitally online. Filing can be done online, and payments can be done online. Thank you very much, everyone.
Thank you very much, Jabulani Kwaramba, for your presentation. Listening to you, I sincerely hope that here in Nigeria, things would become like that. Interestingly, I'm a trademark accredited agent. Yes, filing is done online, but it's not as efficient as you would hope. Things take quite a while, but learning from this, I hope that we're able to improve things here in Nigeria and get things done quite as speedily, especially with the need for us to improve our IP regime and ensure we at least try and meet up with China someday soon. We've seen so many facts and figures about China, and it feels like, would Africa ever come close? But I'm hoping that if we're able to work out our systems, possibly borrowing a leaf from the Aripo system, we can do something grand as well here in Nigeria. Thank you so much, Mr. Jabulani Kwaramba, for sharing your thoughts with us. I'd like everyone to please appreciate Mr. Jabulani Kwaramba for sharing his thoughts with us on the Aripo trademark system. Right now, we're moving. Thank you so much. We're moving right now. If you could please kindly stop sharing your screen, Mr. Kwaramba. Thank you. We're moving on right now into the very last panel session for today. We've had so many insightful conversations all day. Our first panel session was on licensing, merchandising, partnerships as well in the creative industry, taking a look at the opportunities and the risks therein. The next panel session looked at the trade and investment policies that are necessary for business sustainability. We also had a panel session looking at exploring intellectual property insurance schemes. And the last one was on the creation of specialized courts for the enforcement of intellectual property rights. Now we're moving into the last panel session for today, but let me slot it in here and let us know that this discourse is not over today. If you have people that missed it for some reason but should be a part of it, we have quite a number of brilliant master classes slated for tomorrow, Sunday, the 12th of February, 2023, starting from 3 p.m. Nigerian time. So you still have room to invite people that missed day one. They definitely should not miss day 2 of the IP Annual Discourse. We're moving on right now, like I said, to the very last panel session for today. That's not all. We have one more keynote speech, a closing keynote speech by Mrs. Chinyere Okorocha, and I'm sure that you would definitely have a lot to learn from that as well. Panel session 5 is focusing on the insights for building a sustainable trademark system. We've heard from what the Aripo system is like. Can we replicate that here in Nigeria. To moderate this panel session is the convener of the IP Annual Discourse, Ms. Ololade Oloniyo. Can we please put our hands together, welcome her as she comes on board, taking the virtual stage.
Thank you so much, Dami. Thank you. So we are supposed to start a panel section right now. It's insights for building a sustainable trademark system. I'm pretty sure that I have all the panelists here. So I'll just go ahead to read out the profiles of the panelists before we start. Yes, so I would be moderating this section, and of course, my name is Ololade Oloniyo. I'm a partner at Starfield Legal and the sector lead of the technology, media, and entertainment arm of the firm. I'm also the CEO of IP Business Capital, which is a business advisory firm providing cutting-edge IP solutions to African institutions. Yeah, so I'm the convener of the IP Annual Conference, the IP Annual Discourse. It's a platform that serves as a think tank where policymakers, investors, and creative executives, IP professionals, business owners discuss the future of intellectual property, proffer solutions to existing obstacles, and chart the way forward for the growth of intellectual property and IP-intensive sectors. I'll be moving on to the next panelist in this panel discussion. Mr. Max Ikongbe, please pardon me for, I don't really know how to pronounce the surname, but Mr. Max Ikongbe, right? Mr. Max is the principal and founder of Everlaw Associates, a commercial law firm operating in Abuja and Lagos, Nigeria, offering clients a full range of legal services. Is a 2028 recipient of the Esquire Legal Awards, 40 under 40 category for young lawyers shaping the legal profession in Nigeria. He is an experienced litigator who has appeared in all tiers of courts in the Nigerian legal system. He has several landmark judgments to his credit and advises both foreign and local businesses on a wide range of legal issues, including litigation management, arbitration, labor and employment law, taxation, regulatory compliance, and intellectual property. Mrs. Inta Ekpen is an intellectual property expert with over 10 years of experience in the field. She was called to the Nigerian Bar in 2017. She holds a master's degree from Swansea University, Wales, United Kingdom. She's an alumni of the United States of America International Visitors Leadership Program on the protection of intellectual property rights. She's a chartered secretary with the Institute of Chartered Secretaries and Administrators, United Kingdom, and has a certificate in Copyright X from Beckman Klein Center of Harvard Law School. Mrs. Onyekachi is a lawyer, a trained mediator, and an intellectual property professional with 7 years of practical experience in industrial design, patent, copyright, trademark, search filings, registration, opposition, infringement, enforcement, and of course, awareness of intellectual property rights. Because of time, I won't be able to read out all the profiles. I won't be able to read out the full profiles of all the speakers. Please bear with me. Mr. Nosak Wade is a multidisciplinary background. He has a multidisciplinary background, pardon me, please, in law, media, marketing communications, advertising, and corporate communications. He has organized several workshops on IP and engaged in many presentations on intellectual property rights in Nigeria to various target audience, especially SMEs and small and medium-sized enterprise businesses. He's constantly engaged in legal advisory, legal risk consulting, legal research, and drafting for various businesses, leading to improved profitability on their businesses. Over the years, with various clients, he has worked with various clients in virtually every sector of the Nigerian economy: banking, FMCG, breweries, pensions, e-commerce, food seasoning, telecoms, soft drinks, NGOs, automobile, financial institutions, and oil and gas. Ladies and gentlemen, please welcome all the panelists to this panel conversations. Please, can I have some emojis and some hands being clapped in the chat box? Thank you so much to all our panelists for making it out today. So yeah, we get right into the conversation. Let me just quickly, I can see that a couple of people are now. Let me just quickly add others to the panel box section. Okay. Yes. Okay, yes. So let's get right into the conversation. Our topical discussion is insights for building a sustainable trademark system. We know that having a sustainable trademark system is capable of improving and growing the licensing and merchandising business of creatives. I mean, Africa is taking the lead with content, and Nigeria is creating amazing content. The truth is, we can only harness the benefit of our content if creatives believe in our trademark system and the enforceability of their rights. Trends also show that new sectors such as manufacturing, new fashion, product development, and even e-waste companies are now using recycled products, right, to develop and manufacture new products. So we see that we have new trends growing beyond just entertainment and music. So there's a need to have a solid IP system to encourage licensing and the enforcement of IP rights. So this panel conversation is focused on tactics for building a sustainable trademark system in Nigeria. So let me start with Mrs. Onyekachi. We realize that it takes a lot of time for trademarks to be published in the journals, right? Thereby delaying the process for the registration of trademarks. To be honest, this has made lots of brands and innovative companies to lose confidence in the entire system because it looks like registration takes a whole lot of time. People are beginning to even think that acceptance letter constitutes a trademark registration. Please, Ma, in your honest opinion, what do you think is the main cause of this challenge, and what solutions would you recommend? Thank you. Is Mrs. Onyekachi on the call? Oh, wow, probably it's a network issue. Okay. Okay, so let's move right into the next conversation while we wait for her to join us. So my next question goes to Mr. Marks. We have seen cases where a name is registered as a company under CAC, and that same name is being used as a trademark for another business registered under the trademark registry. Especially because of the fact that registration of a business name does not necessarily mean that you have exclusive ownership over the business name. In a way, this has sort of made people to lose confidence in the IP system. One of our recommendations really at IP Business Capital is that we have a consolidation of data with CAC, trademarks, and design registry to allow a holistic framework for all of this. What are your thoughts, sir? And is this attainable?
Okay, thank you very much, Lolade, and thank you also, of course, for inviting me to share my thoughts on this discourse. I think this is a really wonderful idea. I really commend you and your team for putting this together. So I'll just jump right in for the sake of time. So when it comes to your question about people using trademarks of existing brands as their company name, it quickly brings up an argument that has raged on for a while in the US between what we call trade names and trademarks. So one distinction people need to make quickly is to distinguish between trademarks and trade names. Trade name is the official name by which a business is known. A trademark is a mark that is used to market goods and services. So typically, while a company, of course, I mean not typically, a company has one name, so there's one trade name, but the products and services that that company produces would have different marks, trademarks that it uses to market them and put it out there in the market. So classic example would be the former arrangement of Coca-Cola in Nigeria. Nigerian Bottling Company PLC was the trade name, the company manufacturing, producing and selling Coca-Cola products. But Coca-Cola, Fanta, Sprite, and all the other products were the different brands and were all individual trademarks. So one company can actually have multiple trademarks. But however, there are times that the name of the company itself begins to function as a trademark because it's also used to identify goods and services coming from that company. I mean, typically in the service space, this almost always happens because once you talk about Zenith Bank, then you immediately make the connection that Zenith Bank, is also the name Zenith is also the, while it's the name of the company, Zenith Bank International PLC, the name Zenith actually also functions as a trademark along with the logo and other elements of the brand of that bank. But however, where it becomes troublesome is, where people begin to use the opportunity for registering a company or a business name or a limited liability partnership or a limited partnership. I'm talking about under the CAMA 2020. You can use that to, infringe on people's trademarks through dilution. So, for instance, somebody decides to register in Nigeria. Let me use a popular one, Apple Technologies Limited, and register this as a company. Of course, anybody seeing that would immediately create a connection between Apple Incorporated in the US and that Nigerian company and assume that, oh, this company is here to, offer Apple branded products. So this is a problem that has been recognized. Even under the old CAMA, the law was very clear. You cannot register a company, a business name, or any other entity under the Company and Allied Matters Act when it infringes on an existing trademark. But with the CAMA 2020, I think a lot has been done to really clarify the position. So Section 852(1)(d) of CAMA 2020 actually addresses this head-on. It prohibits you from registering a company using a company name that is the name of an existing brand. Section 8571 A and B, very importantly, extends it beyond just registered trademarks. It says, look, you cannot register using a name in which somebody has goodwill. So goodwill is a broad term, which would of course necessarily include registered trademarks. It will also include unregistered trademarks. So for instance, well-known marks. So like in the example I give now, Apple can actually come and object and say, look, do not register this company, Apple Technologies or Apple Nigeria Limited, because they are infringing on a mark in which we have a word in which we have goodwill. So even if they are not registered in Nigeria, the fact that they can prove that, look, we are a well-known trademark and all, I believe, would persuade the Nigerian courts not to allow that registration. And also to give teeth to this provision, because unlike the former provision, where CAMA, the old Company and Allied Matters Act, if this happened, you'd have to go to court and it would be quite a lengthy process. So under CAMA 2020, there's a provision for the Administrative Proceedings Committee, which is kind of an administrative, I'll call it like a court set up within we should be set up within the PSC, that's the, within the CSE, and it's supposed to sit at like a high level management committee of the CSE. So part of what you can do is that you can actually bring up petitions before the APC, and the APC on its own can actually make a determination. But in practice, what we have seen was even before now in practice, in those days, we're able to write to CSE the moment we spotted such an infringement. And if the company had not been registered, CSE would actually withdraw the name reservation. And even if it had been registered, CSE had a way of calling the company and compelling them to change their name under the old act. So even up until now, we use that because the APC has not been properly set up yet. So it's quite an issue, but I believe with, and of course, one of the things we hope is that very soon the CSE would set up the APC and allow them begin to sit on these kinds of complaints. So I believe there's certainly silver lining that, this abusive practice of people, diluting people's trademarks by registering it as company names or limited liability partnerships or LPs or any of the other vehicles under CSE, is at an end, and it's just for practitioners to sit up and ensure that they bring those petitions early enough and stop that abuse from happening. Thank you.
Awesome. Thank you for your thoughts, sir. But just to throw a little bit of light and just to put the conversation in context, would you say that it's actually more efficient for the trademark registry now to work with CSE? So in terms of all of these names that have been existing before, we know that they are working with APC, and there's a procedural structure for that. But going forward now, would you advise that there should be some sort of collaboration? So there's that holistic, framework that going forward now we are now working, because I remember that sometimes when you do registration for businesses as well, you find that after registering the business, you get the tax identification number. So there's some sort of collaboration there that, okay, once you register your business, you get the tax identification number. So is that something that is advisable? Can we say that the trademark registry can work with CSE to have all of these names and everything merged together and start to see how going forward we can have a more holistic framework so that there will be no duplication of names too much, such that people don't lose interest in the entire system?
Yeah, thank you. Yes, thank you for pointing that out. In fact, my answer to that is a direct yes. It should be. For instance, South Africa, what they have is actually a uniform regulator. So they have the Companies and Intellectual Property Commission. So essentially, they have everybody warehoused under the same house. That way, they're able to. Ideally, what should have happened is for the trademark registry to harmonize their database with the CSE database. So when CSE is running a name availability search, that search should include a search through the trademark database as well. And even when the trademark is registered also, same thing should happen to ensure also that people are not doing the reverse as well. Unfortunately, from a practical standpoint, this is ideal, but from a practical standpoint, because a lot of our legacy data in the trademark registry has not yet been digitized, it will be really difficult. I know there was a time that WIPO tried to do a digitization arrangement with the Nigerian trademark registry, but unfortunately that didn't work out. I don't know, maybe Onyeka should let us know if that has worked now, or if there's, if that work is ongoing. But ideally, yes, it would be best if they were harmonized, but at the moment they are not, so it's quite difficult. So the best bet we can do now as practitioners is to use the APC or use any of these other mechanisms at the moment. But ideally, yes, they should be harmonized, or at least have access to read each other's database and compare entries against each other. Thank you.
Awesome. Thank you so much, sir. That brings me to my next question. And my next question goes to Madam Oyinkachi. Flowing from what Mr. Mark said, he mentioned that there's been some sort of that. He mentioned that it's important that there's harmonization with trademark registry and also with the CAC in order to ensure that we don't have too many duplicated brand names and trade names, coexisting amongst different owners, different business owners. So that brings me to my next question. So that brings me to my next question. Please, could you please shed some light on, the digitalization process at the trademark registry? I remember while listening to the speaker that spoke before this panel, he mentioned that he spoke about the Aripo system, right? And the fact that most of all that happens right there is actually online, right? We know that trademark registry has been working behind the scenes to come up with a digitalized system where people can actually do their filings online, make payments online and all of that. But when it comes to search, in terms of running a proper search, going into the database of what exists and running a proper search so that people can know if their intellectual property can actually be registered, right? So what goes on behind the scenes? So please, could you please shed some light in terms of the current situation right now with having to digitalize the search system? Are there plans to get that done? Or what are the challenges? Is there anything in particular that has hindered, the registry from making those definite and concrete steps? And if there are, could you share some insights along those lines? And also, if you feel like there are solutions as well that we can take home from this conversation, you could also share as well. Thank you.
Thank you so much, Olalade. Please confirm I'm audible.
Yes, you are. Thank you.
Thank you so much. So picking up from where Max left off, the first thing I would want to say is that there are two filing processes at the office. You have the IPAS that is sponsored by WIPO, which is what some people call the manual system. And you also have the online system. So as it stands, yes, WIPO did some things, but the way it works is not accessible from the outside. So it's more or less like a manual system. It's not as if it's digitized for people on the outside to be able to access the information or to be able to use the platform per time. Or like the online system, which you can access from any part of the country where you are, and then you'll be able to file your applications and then see what's going on and all that. Then in terms of the search and all that, I want to understand that our search system has always been manual. And I know there was a time some consultants were brought in to look into that situation. And also in my capacity as a special civil servant under the Office of the Head of the Civil Service of the Federation, sometime last year, I had the opportunity of serving or working with the DG of CAC. And I did put forward this question severally. And then one of the things he had mentioned was the CAC is trying their best to collaborate with the trademark registry to see how this works out. However, because we are not an autonomous body, we don't have control over what happens or what doesn't happen as a registry per se. And then I also want to use the opportunity to remind everyone that some time ago, CAC used to be a part of the commercial law department, and it was called the company's registry, just like you have the trademark registry. And if they succeeded in pulling out or being autonomous today, I want to say thanks to the stakeholders who were perhaps involved at the time and knew their function and their role and policymakers. And if such can be brought on the table, I believe this issue would have been a past tense a long time ago. Because when you don't have control to decide what happens to you, you need approval from above, then your hands are tied. The ministry decides what happens, even if the CS is ready to sponsor the budget or what it takes to get us just like what you see the CAC. Thank you.
Awesome. Thank you so much for sharing your thoughts on that. So hopefully we would get to a point where perhaps we would get to a point where the trademark registry becomes an autonomous body, right? So that decisions can be taken in the interest of the entire IP system. Okay, moving on to the next question. Moving on to the next question. My question goes to Mr. Nusa. Before now, we had a panel section that spoke extensively on licensing and merchandising, right? And it is clear, I mean, the trends reveal that in the next coming years, beyond just entertainment and even music, We would have more of manufacturing, we'll have more of product development, new fashion, right? Even right now, as we are speaking, e-waste companies are now using recycled products to build and recycle waste, to build and develop and manufacture new products. So what are your thoughts with respect to how Nigeria and even the trademark registry as well can position for this IP growth through the trends that we are seeing? How do you think that we can actually position for growth? How do you think that we can take advantage of the trends that are coming and see how we can use it to revolutionize, the industry and also expand innovation and create a platform where we have lots of IP filing? Because definitely one of the things we are looking at right now is that we increase the tempo of IP filings in Nigeria. If we were able to increase the tempo of IP filings in Nigeria, where we have more filings on patents, industrial designs, copyrights and trademarks, of course, we would raise a signal to the international community that we are developing our IP system and that we are ready for more innovation and more growth. So what are your thoughts in respect to, we are seeing these trends, they are coming. So what are your thoughts in respect to how Nigeria and the trademark registry can position for growth through these trends? Thank you, sir.
Yeah, thank you so much. I don't know if you can hear me. Can you hear me?
Yes, absolutely.
Good afternoon, all. It's really a privilege to be on this panel and on this conference generally. I've listened to most of the discussions earlier in the morning, and I must confess that this is actually more than a handful. I've been hooked on for almost like a drug from morning till night, from morning till now. Well, I've heard what you are saying, but I just want you to know that what you are alluding to is not in the future. It is already here. So there's nothing about future you are talking about. Nigeria is a trading company, is a trading country. I want to restrict my discussions to trademark specifically, because if we were to go the IP route, it's a different ballgame. So let me just control myself and put it within trademarks. So there's no reason why trademarks should not burgeon in Nigeria, because even the foundation of Nigeria with the UAC companies and everything, they are all trading companies. And you can see that the bulk of our resources comes from trading. Essentially, you have trades everywhere. You have Alaba Market, you have Trade Fair Complex, you have the one in Aba. You have, so if you remove trading from Nigeria, there's no Nigeria, because the corporate, even the corporate existence, they are lashed onto trading. The banks get most of their funding, apart from whatever they get, the others they get most of it from trading. That is why you see bankers running after traders and every other, because Nigeria is trading. Even the educated Nigerian thinks like a trader. So that goes to say that trademark is something that is ubiquitous. It's something that permeates every area of our endeavor. And having said that, I want to say that the entertainment and the fashion industry and everything that you are mentioning, and like any other industry, what are the core reasons for trademark? Reputation building, distinction, brand building, to separate yourself, to be able to amortize the benefit of you being, for your source being identified, so that people know that they are buying what they are buying and that they are sure of the source. That basically is what every business is all about. If you don't differentiate yourself, you will die. And trademark basically is one of the key instruments for making that happen. The truth is that we've not even scratched the surface. And I don't want us to look at it that is a regular. You know, the issue with government is that we tend to put everything to the regulator. But I also tell you that we stakeholders, we need to do a lot more. We need to do a lot more. Most of the time, we are not in bed with the trade. We are not in the trade at all. The lawyers are not in the trade. All the stakeholders are not in the trade. The regulators are not in the trade. Because if we're in the trade, like you said, a lot of developments that have come up, even in the past 5 years, you will discover that most of our laws, the laws that we have, are not going to be able to catch up with them. Because, I mean, look at how long some of the laws we are trying to get through the legislature have taken. We don't know whether it will happen in our lifetime. So our regulation, our laws, and our practice is not in tandem with what the industry needs. It's not in tandem with what trade needs. Look at what has happened in the fashion industry in the past 6 years. What laws, what trends, I mean, what are you going to use to be able to cope with that? If you look at the laws of, for example, even let's even look at the basic, we don't have any statistics. Nobody can tell me how many companies are in Nigeria. You said something about CAC now. It makes a lot of sense that if a company is registered with CAC, it should automatically be registered, I mean, with trademarks and every other thing, because you open the company to start a business. Is that not so? To start a trade. Now you register with CAC, you are not registering that which ensures that your reputation in the marketplace is protected, that gives you the monetary benefit that you are looking for. So you discover that many of us we don't have statistics to tell us, even I don't know, as I sit here, how many people have registered with the trademark registry. I don't know how many businesses. So you see, we grapple around for statistics, and it doesn't happen in other countries that do all these things you are talking about. As of 2020, we had 39.6 million SMEs. How many of these SMEs are registered with the trademark registry? Even if it's just the SMEs alone and the SMEs, I can tell you that all of us will be eating pretty well if half of these people are registered. This economy cannot grow without the SMEs and MSMEs becoming the next level multinational companies. I'm not even talking about the so-called big ones that have, and how many of them are even running out of Nigeria because of the economic situation. But how many SMEs can run out of Nigeria? Don't also forget that SMEs are actually the engine room. They are solutions. Most SMEs are solution providers, like the fintechs and many of them. We need to be able to protect their business, but we have not evolved in terms of IP and in terms of trademarks to be able to protect them sufficiently. There are so many things that need to be said, because if you look at it, for example, like Japan now, Japan has been able to have what you call new type trademarks, because they've been able to identify that beyond the traditional trademarks, there are many other trademarks that need to be protected if those industries are to grow, like the entertainment, like the fashion. For example, in Japan, you can trademark sounds, you can trademark color, you can trademark motion, you have motion marks, you have position marks, you have holograms, trademarks, because these have grown as a result of marketing. Trademark is essential for marketing. And when you are marketing, you are doing things that your competitors are not doing. So you now discover that the trademark regime and system of those places have also evolved to take care of those things. Can we trademark hologram in Nigeria when most of us don't even know hologram? But hologram is what is used mostly for main entertainment industries overseas, where you see people appearing on stage and on shows without them physically being there. Do you get what I'm saying? And these properties belong to a lot of people. The Taiwanese have been able to say, okay, let's make one application, but go into various categories. Can I go into the trademark registry today and make one application and say I want to file for 12 categories with one application? Is it possible? Even though the fees are separate. So there are so many issues that, and I don't want us to restrict it to only
Thank you,
yeah.
sir. Yeah.
Yes,
Awesome.
let's leave it at that. Maybe if I have another opportunity, I'll say more, but there's still much more that needs to be done. That's the truth.
Thank you so much for your thoughts. I absolutely agree. There's a lot of renovation. I mean, our bills, our laws, they have to be adjusted to the current reality. And thankfully, we have a trademark bill and a copyright bill. Hopefully, those bills will be assented to and they will eventually become laws, right? So we're looking at a whole lot more in the industry so that by the time more innovations are coming in, we will be able to catch up with relevant laws and relevant regulations, right, to protect the creativity of creatives and innovators. Going forward, my next question would actually be to Onyekachi, actually. So yeah, just a follow-up on the initial question that I asked you before now. Is the trademark registry, because you mentioned that WIPO did something, but it was manual, and there's a need to get, you know, the body autonomous so that we can have more movements and all of that. So I just wanted to ask, is the trademark registry actually open to collaborating with private bodies, I mean, private institutions, in a bid to build a digitalized system from search to certification of intellectual property? And then the second question is, what will be your thoughts on having a regulated accreditation system that allows only qualified IP practitioners to operate as IP consultants? Because I believe that this will put some sort of credibility into the system and also reduce bureaucratic processes.
Thank you so much. So to the first question, yes, the trademark registry is always open to collaborations. But like I said before, we are not a body that is autonomous. So you have to understand how ministries and agencies of government work. We have rules, we have things we must not go against. There are things we do, it's called abuse of power. There are things you do, you have to be called to order, that you have broken the rules. So you should understand that the registrar himself is a civil servant, and there are rules he must abide by. So these are some of the reasons why it looks like maybe we are not open to collaboration, but why not? Of course we are. So what happens in a situation like that is, even when you are, the rule does not allow you to accept maybe gift or some support. Like take, for instance, there are situations or there are days we go to work, you have to sit from morning to night, no electricity, no network. Sometimes it goes into weeks, sometimes into months, and nobody comes to your aid. And when that happens, you might see some law firms who are actually willing to support with the generating sets. And then you are told orders from above you can't accept. So this is an instance of what happens in the real sense. So it's not as if they're not open to it. So until we become autonomous, there are things we can't do by ourselves. So it's the major solution to all the challenges we face at the office. It's the reason for delays in the work, in the acceptance letters being issued at appropriate time. Not that we can't work with timeline, but so many things are messed up simply because we don't have a say. I take you back, for instance, the MDA and then the trademark registry, for instance, we rely on budgetary allocation. So every year we know what it takes for the budget to be passed. And after it's passed, it takes some time to get to the MDA. And then when it gets to the ministry, it's divided across all the departments in that ministry. Mm-hmm. And then when it is received by the trademark, maybe commercial law department, it is further divided because we have two registries, the patent and designs and then the trademark. And then under the trademark, you begin to consider what are the other things this budget is meant for. So in a situation where ideally you should have publications as per the act and in due course, you're not able to do that. One, because the budgetary allocation is too little. There's no support coming from anywhere. Before now, we used to get what is called 20% derivative. Maybe since 2012, because I joined the registry in 2014, so I learned like a year or two before I joined, they stopped getting that. Nobody's asking questions. Where are the stakeholders? Where are the policymakers? Why can't we get this 20% derivative? What is a 20% derivative? It means if in a year, for instance, you make 1 million naira, you, the body that made that 1 million, you're entitled to 20% of it as an incentive. So the staff in the office, one way or the other, they are encouraged to do more work, not like you bribe or you give them money, no. You send them out to train or for trainings or they attend workshops and stuff like that. At the end of the day, you pay for the DTA and all those stuffs. So it's attached there. And then sometimes when the office does not have funds as per the budget, you can put your hands into that same account and pull out some money to support the system. But until we become autonomous, or at least until the 20% derivative gets back to the registry, there's little or nothing anyone can do about what we have at the moment. Not that we are proud about it, Not like the staff are happy about it? Or how do you feel when you go to work for a period of 1 month, no electricity, sometimes no network? Even if you are so passionate and you want to use your money to buy data, would you also carry generator from your house to work? So these are issues. Like I said, we have 2 different filing systems. So for someone whose schedule is attached to the manual system, would you carry generator to work as well? You can't. So even the health and the psychology of people who go to work and end up doing nothing, wasting hours that they will spend doing other things, is also being affected. Now, back to your question, if I'm going to support, what was that again? If I was going to accreditation system. Okay, before now, I think pre-COVID, we used to have accredited agents at the registry. And then we had that ease of doing business by the office of the vice president. And the idea is to take away middleman in the system. So it doesn't look like for SME to get registered or to get protection, they must also pay the extra cost of engaging a lawyer or an agent. So this was the initiative of the government to reduce the costs of rendering services to the masses, which is a welcome idea. So if you say going back to that era, for me, I don't think it's a good idea. That's number one. Talking about you said something about maybe trained IP lawyers or specialized IP lawyers. So I see a lot of these maybe programs or training adverts on IP personnel and stuff like that. And then I begin to ask, who is calling for these meetings? What qualification do they hold themselves? Are they engaging people at the registry? Because IP is two-faced, whether we like it or not. There's that face those in the private sector are seeing, and there's what we at the back end are seeing. So until we both come together, you can't have a full or the training, the motives, it can't be fully delivered. That's
so
just my opinion.
Really the question that's the question that I'm actually asking, right? So my question really is, in terms of accreditation, how can we have a synergy with the registry and private bodies so that we can release only accredited individuals, right, that would operate as IP consultants, right, such that we are not going over this bureaucratic process, having to deal with so much hurdles and troubles and all of that, especially with the fact that, I mean, there's a lot going on. I mean, in terms of innovation, there's Beverly said there's ChatGPT, there's Metaverse, and the thing keeps going, but we don't have too many people who are vested with the required knowledge. So when I'm thinking of accreditation, I am thinking of a system, like you said, where the private body engages, the registry, and there's a collaboration there to have a holistic system where we only have accredited individuals who can operate, accredited trained practitioners who can now begin to operate as IP lawyers and IP consultants in the space. And they are also recognized by the registry as well. So it just helps to aid, right, and reduce all of these bureaucratic processes. So that's why I was asking that, what's your take on having that kind of system, right? That kind of system, can that work?
Of course it can work, and nothing stops us from having that kind of a system. But like I said before, until you're a body who can wake up in the morning and take decision for yourself and decide on what to do and what not to do, there's a limit to your innovations. There's a limit to what you can do. That's the honest truth. So even when you have a good idea, you can't implement it because there's a policy that comes in which you as a registrar must obey. Otherwise you're breaking rules. So it's not as if it's not open to collaboration. It's not as if we can't have accredited IP practitioners who deal directly with the office. But there's this rule saying, lift this situation, we don't want it. We want the ordinary man out there to be able to go online, log into your platform and register their brands. So what can you do about it if government says this is how it should be? So it's just exactly what we're talking about. It takes us back. And then sometimes you'll be surprised that even when there are new innovations, you find law firms pushing back. So it's not all the time it's the registry. It's not always all the time. Take, for instance, the CAC, before they migrated to be what they are today. We recall immediately after the COVID, there was a lot of protest in front of the CAC saying, no, we don't want the system. because people are scared of change. So that's also a problem on its own. So you see even law firms, learned colleagues who will come out to say, no, we don't want this to happen. And amongst these people are the policymakers, they are the stakeholders. And sometimes when you go to a forum, they're the ones that are doing the talking, and then you're just there as just maybe an observer. There's little you can do. So until we all team together and decide what we want and push for it, as a civil servant, guided by rules, there's little or nothing you can do, irrespective of your position. Thank you.
Awesome, awesome. So my last question is this: if we are to engage the registry on this kind of conversation, like, you know, we just had a conversation of private bodies having to partner with the registry to release out accredited agents part-time, right? That people that, you know, can have the ability to actually, you know, do all of this without this bureaucratic process here and there. So whom should we talk to? Are we talking to the registry, to the chief registrar? Who exactly at the cadre of the trademark operations? Who exactly should we talk to?
Thank you so much. For that to happen, there's the office of the permanent secretary, there's the office of the minister, both senior, and then the state minister. So the ideal thing is whatever you want, whatever negotiations you want to push for. And I'm using the opportunity to call out to stakeholders. They're supposed to, you know, take the first step, especially the NBA. You're an association, you should come out and then take over this situation. What you did with the CAC worked, and you can also work with a trademark. We desire it, we love it to happen, and we're waiting for you. Come and intervene. So when you have people like this, go to the office of the minister, you discuss, this is how it should be, in line with global best practices. And this is where Nigeria is. And we want to move from the sports to this. This is what we think we need, based on stakeholders' engagement, and you put it on the table. And then you formulate ideas on how to work through it. That's when we can begin to have such collaborations at such levels. So first thing first, grassroots collaboration with stakeholders, to get them involved from the very beginning with the NBA, Nigerian Bar Association. And I'm glad Max is one of the panelists. Perhaps he's going to take back this message. I know he's a part of the commercial, there's that arm of NBA belongs to. So I think they're the right people to actually take this move and take the lead. Thank you.
Awesome. So we have the office of the minister and we have the office of the permanent secretary. Key bodies, key personalities to engage.
Sure.
Awesome. Thank you. Thank you. Okay, so let's move over to Mrs. Inter. I mean, we've said a whole lot about all of, you know, all the things that are happening within the space and the challenges and all of that. So please, Ma, could you, I know that you're a foremost IP expert in Nigeria and even internationally. Thank you so much for the work that you do. Some of us are learning and catching up. Thank you so much. So my question really is,
go on it. Sure.
My question really is, I mean, let's not even dwell on the negative side of things. Let's look at the brighter sides of things. What major significant developments have you seen in the IP space in the last 2 years in terms of practice and procedure? So let's limit it to trademark. So are there any major significant development that we have seen in the IP space in the last 2 years in terms of practice and procedure? And how do you think we can actually grow and, you know, do more greater things?
Okay, so I'm very excited to be here. So first of all, thank you. And I'm also excited to see someone from the registry. I know that, you know, we usually don't have, you know, government, because sometimes government wants to be silent. And I totally understand that. So I'm very, very excited that Onyekachi has really thrown a lot of insight to the challenges that the trademark registry is facing. And yes, if you deal with the trademark, I deal with the trademark registry every day, literally, you know. So it is those challenges that we see every day, and we're getting to understand as we go along, you know, the reason for these challenges, the things that we can do to help ourselves, you know, and help our clients despite these challenges. In the last, everyone knows that COVID brought a lot of changes to the system, you know, but in the last 2 years, especially, you know, after COVID, because COVID was, you know, a game changer, I found that the registry, you know, development in IP space is, and I'll speak specifically, like you said, for trademarks. I find that the trademark staff are very responsive. They've cut down the middle tape, you know, you have to find someone in the office. I found that the staff are very responsive, and thank God, you know, they are lawyers. So you have people who are knowledgeable, you know, about whatever it is you're doing. You know, you can actually have a conversation with a staff about, okay, so why would you refuse my trademark? Why is this? And the person would explain to you, you know, those issues. Of course, COVID has made us sit anywhere to do our practice. And most times we are, you know, out of jurisdiction. I found that those, the trademark staff and the trademark office itself we don't feel that there is, you know, you have to be there. Of course, you have to have your agent there, you know, one-on-one to sort things out for you. But I've found that, at least this is, you know, informally in terms of the procedure, that the trademark registry officers are very responsive. They're there, they're willing to help. So if there's anything, you know, for me, that has been my experience, especially in the last 2 years. Of course, you know, there's some things that we don't have control over. So we would recommend things like, do we want Nigeria to join, you know, to collaborate more with international bodies? I have used the ARIPO system. ARIPO system is fantastic. It is fantastic. The fact that you can file, you know, one application in 18 countries is great. I don't know why, you know, for example, Nigeria, why haven't we joined the Madrid Protocol? It will make things easier because, of course, Nigeria, giant of Africa, you know that once Africa, you know, is involved, you want to file your trademarks in Nigeria, you want to do Ghana, you want to do South Africa. You know, I don't think we're going to lose revenue because at least I realize that using the ARIPO system, if you want to designate the countries, then you pay the filing fees. So these are one of the things that we're hoping to see in the future, you know, those sort of conversations as to what regional bodies, what international bodies are we going to join to be able to bring, to make our system more robust, to bring in, because I'm sure if somebody wants to, if you're using the Madrid system, even if you wanted to protect your applications in America, but you see that you can actually do it in the same process Africa, I'm sure Nigeria will always be a first tick for, you know, for any brand owner. So I think that we should actually have this sort of conversations and see how we can move it forward. But Onyekachi, please, I'd like to use this opportunity to commend, you know, the registry staff. You guys have been fantastic, especially in the last 2 years, you know, in terms of response, you know, responsive, at least, you know, my experience. We felt like we've taken like 5 steps backwards in terms of publication, because there was a time we had publications, you know, back to back. It was fantastic. So, but last year we didn't have that. Maybe we thought because the registrar had traveled, you know, he was away on sabbatical for a while. But we're hoping that would happen, you know, if we can just fix that problem. But in terms of examination, it's actually, I've had a good experience. It's been great. It's been great. So I'd like to commend, you know, the registry staff for being very responsive. Thank you.
Thank you, Ma. In as much as we feel like just talking and talking, we have so much limited time. And our final closing keynote speaker would actually be taking the keynote speech very soon. But just before we round up, I'd like to ask a couple of questions. That goes to Onyekachi, then we'll come back to Mr. Marks, and then we'll round up. So Onyekachi, in terms of the publications of trademark journals, right? We've seen that it takes a whole lot of time, sometimes a year plus, for trademark journals to be published. Please, could you give us some insights into why this is?
Thank you so much. So for start, until you get your certificate, if you stop your filing system and just obtain acceptance letter, at that point, you're just a person who has intent to register a trademark. You don't own a trademark. And as such, you're limited to maybe claims under passing off, under law of tort, but not a case of infringement. So that's that. So what are some of these costs? I'd mentioned before that the budgetary allocation is quite low. It doesn't come out so quickly. And when it does, the distribution of those waiting for it are just too many. And then we don't get a 20% derivative. And as it is, government changes or people who are heading the office or the ministry, I beg your pardon, they do change. And then it depends on the stakeholders, like I'd said before, because I take, for instance, you go to the market, you purchase a good and you get home, it's not working. Would you just sit back and look at it? Because we are there to render services. So if you think our services are not good enough as per the publication system, why don't you come forward and get to the very root of it? See those in the leadership position and then make them understand what the act states and what should be done and how you get embarrassed by your clients because your jobs are not being published and on time. We would love to see your publications. We love the business to move. We enjoy seeing it. And when it doesn't, but from within, like I said before, we can't do that on your behalf. And then the issue of proper scheduling system, sometimes that can also be a factor where you can say, okay, this is the designation of this person, or this is a schedule for this person. Like I think I'd mentioned before, I'd said with the DG CSC, and I was sent there by the Office of the Head of the Civil Service of the Federation to see firsthand what they did, how they achieved it, and what is working for them. Don't forget, like I said, we're housed together before. And then our systems are invariably still the same. Exactly what we do is what they do. And theirs is very fantastic. I would love to see that. And I kept pushing for it. And then what I was told is, the money is there. We are willing to give the support, but, and then we are also ready to accept it. But because we don't have control and we don't have final say. So we need your people to come out and find out and see how you can help the situation work better. Then talking about creation of awareness. Like currently, I'm one of the 118 special civil servants under the Office of the Head of the Civil Service of the Federation. So one of the things I do is to create awareness to top government officials. And so far, we've been seeing some tweets or some things that we can say, okay, this is coming from this awareness creation. Except for in the service, you don't take glory for things. It has to always go back to the head and to the system, but we know it's working. So what I want to say is, if while doing that from within, what about the stakeholders? What about the policymakers? When you have a chance to speak, do you speak for? Or are you considering the money that goes into your pockets? And then you hold back because the system benefits you and you're not considering where the country should be because other countries are along there and then we need to catch up. So these are questions we must ask ourselves. Law firms should stop pushing back. This change is beautiful and it should come through. So these are some of the challenges. And then what can we do? Okay. With the federal government, the ease of doing business, I had said that before. We need to have more synergy. With the CAC, you had asked that question before. It's fantastic. I also put that forward to the DG. And then in as much as he has his own opinion of how things are done or the names, there can be conflict to some extent. We can't deny the fact that sometimes there is conflict. And then I know I've received calls to ask me questions or who takes the right first and all that since visiting them, since working there. So I have some of the staff reach out to me on such similar issues. So these are things we'll see out there in practice. What is the judiciary doing about it? Can we have a standing position? Because the judiciary, they interpret the law. Can we even test the law? Our lawyers are available to test the law. It's not the time we negotiate. Sometimes we get stubborn, get to the end of it, because we want the judiciary to speak and speak well. So imagine you have two formidable lawyers standing before the judiciary and stating what should be or what things are. And then the judiciary is forced to we move to the Supreme Court to push for it. This is the final say when there's a conflict between those two, we test the law. The law is not enough just on karma. We need to test it. And I don't know if that has been tested so far. Then training, we have to train and retrain staff, especially the judiciary as well, because there are some cases I see out there, the judgment, I'm like, did the judge really say this? Does he not know Nigeria is a dualist state and we can't be bound by some international treaties because we're not a money state based on Section 12 of our Constitution? Even whatever laws we sign until they're domesticated, they're still not a part of us.
Thank you so much. Thank you so much. I mean, one of the things that I picked was the fact that the funding is one of the crucial things that hinders publication of journals, right? I believe that all stakeholders on this call are also taking notes as well, because I think it's time for us to get in there, make those negotiations and get what rightfully belongs to us. That's so, so important. So the last question right now, thank you for all those amazing suggestions. I definitely took them down, Madam Onyekachi, and we will be working towards those things gradually. Thank you so much. The last question goes to Father Max as well, Mr. Max. So yeah. So yeah.
The name sounds like that of a priest, so it's okay. I'm sure he doesn't mind. Max.
My last question goes to you, sir. From a trademark litigation perspective, what top 3 recommendations would you give for creating a sustainable and efficient trademark system, for creating a more sustainable and efficient trademark system? Over to you, sir.
Yeah, so 3 things, and I'll just go quickly because I know we are already out of time. Number 1 is that the Federal High Court should pass a practice direction or include something in their rules for grant of Anton Pillar orders. You find somebody infringing on your, on your mark, you go to court. It's difficult to, because sometimes you don't have the full information. You need an Anton Pillar order, essentially search and seizure order to, be able to know the extent of infringement and even get information, get enough sufficient information to prosecute your case. But our courts have become so reluctant to grant those orders. It's become quite, and I get the point, because there's been abuse sometimes where even the infringer actually goes to court, gets the Anton Pillar order and shuts down the business of the real owner of the mark. But I think there should be a practice direction that governs how it should work and make clear provisions. Number 2, there should be an enhanced provision for security for cost. So typically, you institute a case against an infringer, he comes to court, and then he just begins to play delay tactics and is wasting the time of the court. So there should be a provision where, look, if you come to court and you claim you're a genuine business, you're not an infringer, then furnish some significant amount of money as security for cost. That would actually dissuade those outright infringers from coming to court and wasting everybody's time. Then number 3 is a simple thing, and it's something I believe the trademark registry should work on urgently. Now, the format for trademark certificates has a disclaimer at the bottom. This certificate cannot be used for litigation purposes or abroad. That's a big issue. Now, I've understood from the trademark registry people that the reason why that was based on the formal provision of the law, that original copies of public documents are not admissible in court. So the idea was that whenever you had a litigation, you're supposed to go back to the registry and do a certified true copy and tender that in court. But that has become, a huge issue. So I had, a case going on now, and the person took objection on that basis alone. We had to actually, subpoena a staff from trademark registry to just come explain this simple thing to the court. And of course, we have to do that because sometimes our judges can say, look, on that basis alone, we refuse to admit your certificate. And so the trademark trademark regulations 1967, where that format of certificate comes from, should be amended to remove that disclaimer to avoid these challenges. Thank you. So that will be my 3 top tips. Thank you.
Awesome. Thank you so much, sir. I've had a very insightful conversation with the panelists, and I'm glad that the conversation was quite honest, and we are able to glean, right, and hear from top experts and also officers at the trademark registry to see where we are, right, the right steps to take, and the solutions that we can begin to work towards too, so that we have a more sustainable IP system and trademark system. Thank you once again to all the panelists. Thank you so much. I'll be handing over to Damilola right now to continue with the discourse.
Thank you very much. Thank you so much, everyone. A very big thank you to our panelists as well. for chipping in and giving us their very, very brilliant contributions. Can you kindly please appreciate our panelists and our moderator as well in the comment section, letting them know 1 or 2 things that you have learned from listening to their own perspective when it comes to building a sustainable trademark system here in Nigeria. We're gradually coming to the end of day 1 of the IP Annual Discourse 2023. But just before we do that, we have our second and final keynote speech from Mrs. Chinyere Okorocha. Mrs. Okorocha is a celebrated senior lawyer, career mentor, public speaker, author, business leader, entrepreneur, wife, and mother. I must say, as she has said as well, that she attempts to live life to the fullest. She's a partner at Jackson, Etsy, and Edu, a top-tier law firm headquartered here in Lagos, Nigeria, and she has over 30 years practical experience covering specializing in intellectual property law, helping international and local clients protect their intangible assets. Ms. Okorocha is an accomplished, highly respected lawyer by peers and clients alike, with accolades and recognitions, including her recent appointment as the chairperson of the Nigerian Bar Association Women Forum, NBAWF. She was also the past council member and treasurer of the MBA section on business law. She was the inaugural chairperson of the Intellectual Property Law Committee of the NBA section on business law. Mrs. Okorocha is one of the leading individuals in intellectual property law in Nigeria. She has been recognized as an expert in the Who is Who Legal from 2017 to 2022, to mention a few. I personally am super excited to listen to her as she shares her thoughts with us on the theme, intellectual property as a catalyst for SME growth, economic development, and investment promotion. Ladies and gentlemen, please give a warm welcome to Ms. Chinyere Okorocha.
Thank you so much, Damilola. Thank you so much. Good evening or late afternoon, ladies and gentlemen. I'm delighted to be here today. I'm excited to be here. I have actually spent my whole day practically listening in on all the sessions. And I must commend the organizers of today's event for putting together such a robust discussion on my favorite topic, intellectual property. I mean, the panel discussions have been so robust, you know, and the speakers came with their all. That's the only way to put it. They all came with everything they had to ensure that every aspect really of intellectual property was covered. And it's so interesting and heartwarming for me to see where this aspect of the law that I cherish and I love so much has developed and evolved into. I believe that on all your panelists today, I am the oldest of them in terms of intellectual property practice. I stand to be corrected. I've been practicing IP for 32 years. And in that time, it's so interesting to see the evolution of the practice of IP in Nigeria and where we're taking it to. And I'm so, so proud of everybody who have spoken here today, some who I've known personally, some who I've also watched their careers as they've evolved, and some who I'm only getting to know today. You know, so well done to the organizers for putting together this august team of speakers and panelists. And so, to speak to the theme of today's conference, by way of a closing keynote, I'd like us to consider for a moment the whole ecosystem of intellectual property. When I started out as a young lawyer, I happened to do my law office attachment in a firm that practiced intellectual property law. And that firm was the first idea I got about what even intellectual property was. I mean, yes, we did it in law school. We touched on it, you know, on a very, very small scale, you know, as to what it was, but we didn't truly understand it. But when I did my law office attachment in this firm, it expanded my mind that law is more than just going to court. With no offense to the litigators in our midst. And then I happened to do my youth service in that firm also. And then I was totally exposed to intellectual property. It was so curious to me, you know, that this topic, IP, covered every aspect of human endeavor. And I dare say it's the only part of the law that actually does cover every aspect of, you know, human endeavor, every industry, every sector, really. And I want you to take your mind back to a scenario of a human being and the journey they take, just a little journey from the minute they wake up in the morning to the time that they get to their office, wherever that may be. And to imagine the amount of intellectual property they come in contact with in just that short journey from their house to their workplace. So let's consider you wake up in the morning. A lot of people wake up in the morning and look at their phones, you know, so you look at your phone and your handset, and that's my phone. Your handset is protected by intellectual property, both in terms of the name of the company that made the phone, in terms of the broadcast with it that you can emit from the phone, in terms of the shape of the phone, in terms of the engine of the phone. So I've talked about trademark, patent, and design just in a handset. And then you get up and you put on the news, the television you're looking at. And the TV, of course, is branded LG or Samsung or, you know, whatever it might be. And then even the TV, the broadcast, the channels or Arise or CNN or Sky that you're looking at is a broadcast. Then you go to the bathroom, guys, just to take a shower. You come in contact with the toothpaste, the toothbrush, the shower gel, all intellectual property. Even the sink and the bath that you're about to use are all branded. Then you want to have your dressing up, the shoes you wear, the bags, you put on the clothes you wear. You want to take your breakfast, the cereal you drink, you understand, or indeed any other food that might be packaged food with an IP trademark name. All this, you haven't left your house. And then perchance you enter your car. Of course, your car is branded. It has a name. And you get in the car, you're driving along the street, you put on the radio inside your car, then you're hearing Cool FM, what are all those radio stations? 99 point this, 99 point that, you know, all of them, radio stations, branded, trademark, copyright, all of them mixed together. Now you're going on the street and looking at the buildings and you see this bank and you see that logo and you see this billboard and you see a school and you see, you know, an office, and names and brand names are everywhere around you. IP is everywhere. And those that have, the countries and the nations that have tapped into the importance of this phenomenon are the ones that are thriving. If we go back to the United States of America, for example, and I got some statistics, you know, that I would like to share with you today in terms of how IP has impacted the US economy. And the US economy is the largest in the world, you know, in quotes. Because we know who is struggling for that #1 position. So it says USA, the IP worth is valued at $5.8 trillion US. The value of the intellectual property is valued at 5.8 trillion. And then the industries, the IP inclusive industries account for 1/3 of the total US GDP, 1/3. I mean, that is mind-boggling. And then it says IP accounts for 74% of their exports. And it totals about $1 trillion US. The total exports in the United States, 74% of them are IP. And then again, IP accounts for over 40% of the US economic growth. When I saw those statistics, I truly felt they were mind-boggling. They are truly mind-boggling, but this is a nation that has come to realize that creativity and innovation is the bedrock of any economic growth they can imagine. When I look back at society of where we were hundreds of years ago, or let's say 50 or years ago, you know, the creation, or let's say, yeah, creation of the light bulb, for example, or the innovations we've had with electricity, with sound waves, with the creation of the television from the, you know, manual to electronic, digital, you know, to the streaming of music now, to Bluetooth technology. You know, now in IP, we're talking about Bitcoin and where IP comes in there, and NFTs and all that. This is all about intellectual property, the ability to sit down here, you and I, and to think up an idea in your mind's eye, using your creative genius to create an idea, a concept, to create a name, you know, a design, whatever it is, and, you know, put it in a fixed medium or industrialize it, and then having some form of economic benefit from it. That to the exclusion of everybody else. That is basically what IP is. As we have learned from all the panels here, and I say that this is an advanced course in IP because we started from an advanced level in our discussions. It's not basic. There's nothing basic about the discussions we've had here today. You know, and that was what endeared me really to the entire discussion that we've had. So where does that leave us as a nation in Nigeria? Where does it leave our SMEs? Do they even know what intellectual property is? We have touched on various aspects of it today, but for me, one of the most important things is creating awareness in the minds of the purchasing public that it is not okay to simply Google a name and use it, or that it's not okay to copy someone else's design and use it, because a lot of them don't even know. They think it's okay. They don't know that there is something called intellectual property that grants the owner the ability to enjoy any benefit, financial and otherwise, to the exclusion of everybody else. And that awareness is not only in the minds of the purchasing public, but it's in the minds of the government. Respectfully, I say, our government is not truly aware of the potential they have if they invest, you know, invest properly in innovation and in intellectual property. And so that is why we're in a place in Nigeria today where our laws are all, both our trademarks, our patents, our designs, our copyright, at least those 4 main types of IP, all our laws need to be updated. I know that we've got the IP Trademark Act, you know, waiting to be passed, and the copyright one and all that, and indeed an IP policy for the government to actually put into place to kind of sensitize the entire system. But when is it gonna happen, guys? I told you, I've been practicing IP for 32 years. And when I started my career in 1991, we were attempting to pass a trademark law. That was 1991. I often say that I failed. I was the chairperson, is it chairperson we called it, of the IP committee of the section on business law. I held that position for 7 years, and it was my life's desire to be among those who managed to get our new Trademark Act passed. And I say I failed. Or maybe, you know, we set the foundation, but we're talking about 32 years, guys. But I dare say, if it was something to do with the oil and gas industry, it would have been passed in the twinkle of an eyelid. So that basic understanding on the terms of government, that we need to invest in intellectual property, because it can be a basis for economic growth of the nation. Look today how the Nollywood has taken over and the music industry. You know, I recently got back from the United States of America. I got in a taxi and all the guy was, and it wasn't because I got in the taxi. The guy had a playlist of Afro beats and he was trying to explain to us why people, you know, they were there. Burna Boy, what are all of them? Tell me in the chat box, guys, what are all the Nigerian artists? At least all these young Afrobeat people, you know, Wizkid, Davido, Thames, you know, all of them. He had a playlist, guys, and that was all he was playing. And then he now told us, which one do you want? This is an American guy. What other exports do we need? Are we capitalizing or leveraging on the IP that exists here in Nigeria? We continuously hear of situations where we create the IP and then, you know, they call Fireboy, Ashake, thank you. You know, and the Western world, they come, they go monetize it and they sell it back to us. When are we going to learn? China pays its citizens to register their intellectual property assets. For everybody that registers, I don't know, one ridiculous amount they dash you if you innovate or invent something and you register it as a patent. They have the highest rate of patents, you know, worldwide. So what are we doing as a nation? When is it going to change? When are we going to create an ecosystem that allows IP to thrive? We've talked today about foreign direct investment. Truly, Africa, the third world countries, as they call us, is open to investment. But people are only going to invest in a situation or in a country where they can be guaranteed their return on investment. Is our environment an enduring environment to invite foreign direct investment? Because their own economies are saturated. They're looking for virgin ground to sow. Nigeria has over 200 million people. We are the focus if we can get our act together. We are the focus if we can put our policies in place that create that environment for IP to thrive. And so why is IP so important? I've talked about foreign direct investment. I've talked about the economic growth that can come from it. What about even bettering the lives of citizens as a reason to invest or promote intellectual property? We've talked about how, I mean, even just take the example of COVID-19 pandemic that just passed. The way the global community came together to invest in the R&D that enabled them to find a vaccine. That's what intellectual property does. It promotes innovation. It gets those creative juices thinking about how a problem can be solved. That's what IP is about, and that's why it's important. It improves the lives of all and sundry, all of us. You know, so SMEs, if we come back to the topic, SMEs drive the economy. There are more SME companies. I think they make up about 90% of the entrepreneurial, businesses in the Nigerian economy today. But what are we doing? Do they know about IP? So it's initiatives like the one we've had today that will help to sensitize the public as to the need to register their IP, to invest in R&D, to ensure that they are protected, to continue to create, to innovate in terms of intellectual property. So I know that the day is fast spent. Was there anything? Another thing I thought, I'm looking at my notes, I thought it was important to mention today was the issue of collaboration amongst agencies. The last panel touched on it a little bit, but I thought it's important to mention the fact that in order to have a robust and effective intellectual property regime in Nigeria, different agencies through which we are able to protect, to enforce our IP, they must speak to one another. I know there was a focus in the previous panel on the discussion or the collaboration between the Corporate Affairs Commission and the Trademark Registry. But it doesn't end there. I have about 5 agencies that I know we can use, or we do use as IP practitioners, to promote the protection, regulation, enforcement of IP. So you have the Trademark Patent and Design Registry, you have the Copyright Commission, you have NAFDAC, you have the Standards Organization of Nigeria, you have the CAC, I believe customs too comes into play. Or each person, everybody is doing their own thing, and at sometimes there's a clash. But if there is synergy, proper synergy that is imbibed in our laws and in a policy document, excuse me, that ensures that each person, it's like the 5 fingers of the hand. There you go, 5 fingers of the hand. Each part needs to know what the other is doing. And that creates the synergy required to have a robust IP regime. So I think the onus is on us. I believe everybody here is an IP practitioner. The onus is on us as lawyers and key stakeholders, or an IP regulator, to ensure that we sensitize the public, that we continue to apply pressure on our government to take IP seriously. Perhaps to come through the entertainment industry, which appears to be doing so well. But how sensitized is our entertainment industry? Even the artists themselves, are they aware of their rights? Are they aware that they need legal representation to protect themselves from exploitation? Are they aware that contracts need to be drawn up, airtight contracts that protect the intellectual property before they give it away for free? There's so many disputes in the public domain that show us that we're more ignorant as a society about IP rights, than the opposite. So in conclusion, my dear brothers and sisters, IP is important for economic growth. IP is important for the growth of our SME industry. IP is important for providing improving the labor industry, for driving innovative and creative activity. For economic growth, it is invaluable. If we're able to take the example of the United States, which I have given today, I am sure you will agree with me that, we're looking for how to diversify our economy in Nigeria, to take it away from oil and gas, right? Is intellectual property, an investment in intellectual property, not a viable option if we harness the potential properly? When you go abroad now, a lot of the innovations that are happening are Nigerians. But when they're in Nigeria, they're stifled. And when they go abroad to the Western world and other countries, they thrive. Why is that? When are we going to get to the place where we foster innovation, where we invest in our R&D, where the budgetary allocation, I heard someone from the registry talking about lack of funds and all that. It's very heart-wrenching that 32 years down the line, guys, I'm telling you, in 1991, these were the same problems. When I started out as a young IP lawyer, we were talking about no light in the trademark registry. I'm buying diesel, buying printers, buying ink for the printer, and all whatnot. How can we still be in that discussion 32 years after? 32 years after, we're still talking about that? When are we going to learn? What does it take? What will it take for our government to recognize that this is important and it's a viable a tool for economic growth? And if you invest in it, you'll be investing in the nation as a whole. So in the interest of time, I rest my case. Intellectual property is important. It needs to be invested into. It can be a vehicle and a tool for economic growth. And the sooner we as a nation get to recognize its importance, create policies and enabling environment for IP to thrive, the better we will be as a nation. Thank you, everybody, for listening.
Thank you so much, Mrs. Okorocha. Thank you very much for lending your voice to this cause for 32 years strong. Thank you very much, ma'am. I'm just going to say and encourage you that with something like this, we all are aware of the fact that change doesn't happen overnight, not to tire, but to continue to keep at it. Thank you very much, ma'am, for opening our eyes to the work that we still need to get done to ensure that the IP regime in Nigeria is where we hope it should be and how it can compete on a global scale. Thank you very, very much, ma'am. We sincerely appreciate you. I also want to say a very big thank you to every single person who was here right from the start at 9 a.m. and is with us at 4:13 p.m. Thank you for spending your day with us. I do hope it has been time well spent for you. For me, it has been. I've learned a lot. My eyes are open to work that should be done. And I am definitely fired up to ensure that when it comes to intellectual property, I would do my bit for it to drive the change we desire, especially in Nigeria's economy. Thank you very much to every single attendee, to every single speaker, and to every single panelist. Thank you very, very much. I'd also like to thank our supporters. You would agree with me that an event of this magnitude has to have been put together by brilliant minds. Collaboration definitely was what made this happen. Now, as I appreciate every single brand that has supported the IP Annual Discourse 2023, please kindly in the comment section help me and say thank you to them as well. Can we please give a round of applause to Starfield Advisory? They're part of the supporters of the IP Annual Discourse 2023. A very big thank you to IP Series. A very big thank you to the Intellectual Property Institute of Nigeria. Thank you again to the Everything IP Law podcast. Thank you to the Truman Rockwood Barristers and Solicitors. Thank you very much, IP Radio. Thank you, OAL, Olisa Agbakoba Legal. Up Notch Consult, we sincerely appreciate your support for the IP Annual Discourse 2023. Intellectual Property Lawyers Association of Nigeria, IPLAN, thank you very much for your support as well. Dara's Media Hub, thank you once more. Accent Consult, thank you very much for helping us put together a stellar program. And of course, our conveners, IP Business Capital, thank you as well for your genuine support and ensuring that we've had an enlightening time and a very, very robust conversation today. Like I said earlier on, this is just day one. Conversations continue tomorrow, 3 p.m. Nigerian time. If you have anybody that for some reason has missed out on day one, today's conversation, let them know that all hope is not lost. We have master classes tomorrow, and as usual, there'll be time for question and answer so that all things are clarified even as you join us for the discourse. We have a number of master classes tomorrow, and I'll just share them with you to whet your appetite, let you know what to look forward to, and of course, encourage you to ensure that you're here and that you're not here alone. You're here with an IP enthusiast, you're here with a lawyer, you're here with a policymaker, you're here with a creative, you're here with a business owner, because what we're saying affects these sets of people. The master classes we'll be having tomorrow are on trademark opposition proceedings, data privacy compliance for tech businesses, anti-counterfeiting measures for brands, licensing and assignment of intellectual property. So you can see that we have a good number of robust discussions that are going to happen tomorrow as well. At this point, I want to say again, thank you so much for sticking with us from 9 a.m. Nigerian time till this very time. My name is Damilola Busari, and it has been my honor to be the host of the first day of the IP Annual Discourse 2023. See you tomorrow. Do enjoy the rest of your day. Bye.